We are now live and recording.
Good morning, and welcome to the Board of Trustees meeting of the California State Bar. As a reminder, this meeting is being recorded. Board Secretary Sharon, please have the roll.
Barahona,
Present.
Buenaventura,
Present.
Cisneros,
Here.
Good, not present. Gore, here. Grande, here. Harrison, not present. Huser,
Here.
Giorgiello,
Present.
Soel,
Present.
Stevens,
Present.
Tony.
Present.
Chair, you have a quorum.
Thank you very much. Next on the agenda is a call for public comment. Before we begin public comment, I would like to remind everyone of some of the ground rules for speaking during this meeting. Under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the Board of the State Bar's governing body is the State Bar's governing body and is responsible for exercising oversight of the State Bar. The Board, sitting as the Regulation and Discipline Committee, oversees the work of the attorney discipline system. Under the State Bar's policy regarding public comment, members of the public cannot cede their time to another speaker. Any attempts to deceive the board by disguising your voice, using different aliases or names to participate in public comment or accent is, by extension, not allowed, as well as impermissible under the State Bar's policy against disruptive and/or disorderly conduct that may result in removal from the meeting. We appreciate your cooperation in maintaining a respectful and orderly environment for all attendees. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now and State Bar staff will call on you in the order that hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. Doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open your microphone so that you can address the board. Under the State Bar's public comment policy, each speaker is allotted 2 minutes. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. Board Secretary, how many members of the public in total would like to make public comment?
We do have 3 advanced signups today, and I do see some raised hands. I do want to confirm that I do not see any commenters in person at the LA office.
Thank you.
And I will move on to the advanced signups. First, we have Henri Marini, who I don't see in the attendees list. Next, we have Benjamin Cohn. Your mic has been enabled.
Thank you. I wanted to address the preparation for the 2026 legislative priorities. I know that's not agendized for today, but I think you should start thinking about what should be agendized or what should be requested of staff to look into in the meantime, especially as the potential pursuit of what I'm about to suggest would affect an item that's on the agenda tomorrow for the joint meeting. So I want to suggest that you at least try to seek amendments to the notice statute that was put in place last year, requiring 2 years advance notice for the standard condition of remote testing, as well as 18 months of advance notice to use a multiple choice vendor other than the NCBE, at my position, at least to the extent that that is validly imposed. It may be that it's preempted if the NCBE, as its CEO, told the Committee of Bar Examiners at the December meeting, refuses to consider testing accommodations like remote testing at all under any circumstances as a purported not opinion that it can't be securely implemented. But Of course, since that position is incompatible with the State Bar's use of remote testing for the first year law students exam, it's past use of it for many other bar exams besides the failed February attempt that was vendor bound. That position doesn't hold factual merit, and without that fact that it cannot be done, it becomes a policy preference, especially when you've essentially admitted that it's validly able to assess the skills and knowledge intended to be tested on these exams. So it cannot constitute a fundamental alteration under federal law under those facts as you've done it, regardless of the NCBE's preference and regardless of their willingness to license their exams without you agreeing not to offer it even as a testing accommodation. It may be that if you took that position that it is that the notice requirement is preempted, but regardless, it's bad policy to have these restrictions on the next few bar exams, and you should seek to have the legislature voluntarily remove those restrictions through amendments as part of your 2026 legislative priorities. And that should be agendized so that you can decide to direct staff to do that lobbying at hopefully no later than the February board meeting. And as far as the meantime, it's important to give the notice that allows you to make those changes, even if the legislature doesn't, but it should be a multi-front effort.
Thank you for your public comment. Next, we have Kai On. Your mic has been enabled.
Good morning. My name is Kyon. I'm here again about Sacramento DA office provide me fake information. DA case file 99F08735. Fake defendant Jungso Fong hit and run kill my father Woon Kong On. Attorney General Robert Bronter and Sacramento DA Tien Ho did not investigate, but State Bar closed my complaint without any investigation and even not respond to my request for meeting to discuss the situation. It is something somebody tried to cover up a law enforcement scandal 26 years ago in Sacramento. Chair, does the board has any action? Chair, could you respond why the board has no action for my complaint of State Bar?
We're here to receive your public comment. Please proceed.
Okay, if the State Bar had never respond to me, so how can I get the justice from the State Bar Board or Trustee? And why there's nobody respond to me, contact me from State Bar? So it means that the State Bar is helping to cover up the scandal?
Thank you for your public comment. Your time has concluded. I will now move on to the raised hands. Next, we have Ray Hayden. Your mic has been enabled.
Thank you very much. I like the timer. It's very visible. It's nice. Anyway, so I have the preference of a remote exam. I'm the Florida guy. I go to California to take the exam. And we get fleeced every time we do that. The hotel rates, travel, everything goes up, and the price of the exam keeps going up. So these are problematic for repeaters like myself. The remote exam and the options that you're going to look at this during these meetings offer options. I personally like number one the best because it gives California Bar the most option and be able to offer a remote exam and also potentially an on-demand exam. If you check with your own psychometricians, you will find that other career fields actually use pure multiple choice question exams, and they can be done in a variety of different ways up to the hosting presenter of the exam. My other preference would be to also be able to offer the potential for on-demand. But definitely, if you don't have the option for remote exams, you cannot or would not likely be able to do them more than twice a year. And as Trustee Harrison had mentioned previously, and I agree with, is that Kaplan actually has been around for a long time. They deal with a lot of different fields, and they can produce a good product. And even with the fiasco of February 2025, the Kaplan offered materials were actually pretty good, and they were well. And the pass rate, the unfortunate situation, the pass rate, it improved. So with that, thank you, and I hope you have a wonderful meeting.
Thank you for your public comment. I do want to note for the record that Trustees Good and Harrison are present. Chair, we do not have any more raised hands in the attendee list.
Thank you, Sharon. With that, we'll move on to the chair's report. I would like to announce that the following updates have been made to committee assignments. Laura Enderton Speed will be appointed as ex officio member, replacing Erica Doherty as member of the executive committee. And Trustee David Giargello will replace Trustee Gennaro Trejo on the finance committee. I'd be happy to receive a motion.
I'll make the motion to accept the committee changes.
Second.
Motion by Trustee Sowell, second by Trustee Stevens. Vote, please.
Barahona?
Aye.
Buenaventura?
Aye.
Good?
Aye.
Orr?
Aye.
Grande?
Aye.
Harrison?
Aye.
User?
Aye.
Giargiello?
Aye.
Soel?
Aye.
Stevens?
Aye.
Tony?
Aye.
Cisneros?
Aye.
With 12 ayes and 0 nays, the motion carries.
Great. With that, we'll move on to the executive director's report. Laura.
Sorry. Thank you, Chair. I just want to share some updates since our November meeting, some of the happenings here at the State Bar. In December, we held 2 public hearings on procedures for discipline, attorney competence, and admissions, 1 in each location, San Francisco and Los Angeles, continuing our commitment to accountability and stakeholder engagement. On December 3rd, we announced 6 new DEI Leadership Seal recipients and 4 new organizations committed to earning the seal. We now have 85 legal employers participating in the program, furthering greater access to and inclusion in our legal system. And just yesterday, we announced applications inviting a new round of legal employers across the state to apply to the DEI Leadership Program. Those applications are due in late March of this year. We also launched a redesigned website for both the State Bar and State Bar Court. These improvements allow better navigation, accessibility, and mobile optimization, making it easier for the public to navigate and access information. Together, these accomplishments further our goals of restoring trust and advancing transparency, improving efficiency, and protecting the public. Today at the meeting, the Board of Trustees will review our 22 to 2027 strategic plan, reviewing key accomplishments that have been completed so far and key initiatives coming in the next year that further our State Bar strategic goals. And that concludes my report. Thank you, Chair.
Thank you very much. Our next item is the approval of the November 2021-2025 Board Trustee Open Session Minutes. Be open to any changes or comments, and if not, a motion and a second.
I'll move that we accept the minutes.
Second.
Motion by Trustee Sowell, second by Trustee Giargiello. Vote, please.
Barahona?
Aye.
Buenaventura?
Aye.
Good?
Aye.
Orr?
Aye.
Grande?
Aye.
Harrison?
Aye.
Huser?
Aye.
Giargiello?
Aye.
Soel?
Aye.
Stevens?
Aye.
Tony?
Aye.
Cisneros?
Aye.
With 12 ayes and 0 nays, the minutes are adopted.
Thank you very much. We'll now move on to the consent calendar. Item 4.1 is withdrawn from the consent calendar, which leaves item 4.2. If there's any discussion, we can pull it and discuss it. Otherwise, a motion and a second.
I just had a quick question, which was the presiding justice and the reviewing justices have the same pay rate, and that just struck me as unusual.
Is Justice on? No. I can answer, I'm pretty sure. So those rates, we don't actually set rates for the judges themselves, so that's from the direction of what was negotiated at the executive level. By statute, judges get a certain increase based on what particular bargaining units get, and so that's based on the Cal HR pay letter. We don't have control over that.
Right, and that is what I read in the papers. It struck me as a bit odd. I'll move approval.
Thank you.
Second.
Great. Moved by trustee Stevens, seconded by trustee Harrison. Vote, please.
Barahona,
Aye.
Buenaventura,
Aye.
Good,
Aye.
Orr,
Aye.
Grande,
Aye.
Harrison,
Aye.
User,
Aye.
Gargiello,
Aye.
Soel,
Aye.
Stevens,
Aye.
Tony,
Aye.
Cisneros.
Aye.
With 12 ayes and 0 nays, the motion carries.
Thank you. Now on to item 5.1, the Board of Trustees Strategic Planning Session. We'll begin with item 5.1, training regarding conflicts of interest in Form 700 training, presented by General Counsel Deb Tien and Assistant General Counsel Bradley Dewar.
Good morning, everybody. Today's training is focused on obligations regarding conflicts of interest, Form 700 reporting requirements, which are critical components of the ethical responsibilities as board members, which also extend to state bar leadership, staff, and those filing Form 700s. As some of the board members may recall, this enhanced training was developed as part of the conflict of interest reforms in 2023, and this is the third year that Office of General Counsel is providing the training to the board. The conflict of interest and Form 700 training serves several important purposes. It is intended to provide a firm understanding of California's Political Reform Act, as well as specific rules that apply to the State Bar through the State Bar Act. It helps the board members identify potential conflicts before they become issues and reinforces State Bar's commitment to transparency and public trust. The Form 700, or also known as Statement of Economic Interest reporting requirements, are safeguards that allow the public to have confidence that our decisions are made in the best interest of the organizations and those we serve, and not for personal or financial gain. We'll cover what constitutes a conflict, when and how to disclose those conflicts, when to reach out to the Office of General Counsel, what needs to be reported on your Form 700, the applicable deadlines, and some practical scenarios you may encounter as board members. This training is an important component of having a robust conflict of interest process and procedures as an organization, and it's particularly important given that the compliance obligations rest with each of you and us as public officials and Form 700 filers. Understanding and complying with those rules protects both you individually and the integrity of this board and the State Bar collectively. My office has been and will continue to be a resource to you, and are available to answer questions that you might have here or outside of the board meeting to advise you on conflicts or reporting requirements. With that introduction, I would like to invite Brady Dewar, Assistant General Counsel, to begin the training, and I believe most of you are familiar and know Brady from interactions at the board and reaching out on conflicts questions. Thank you.
Thank you, Elaine, and we'll just jump right in. Good morning, everybody. Elaine gave a great overview of some of the whys, so I will go quickly through some of these first basic slides, but just in general,
Brady, would you mind speaking up just a little bit more, please?
Sure. Maybe there's it's not usually the complaint I get, so maybe I'm having a technical issue. Let me know if this is not better. in general, as public officials, trustees, and on all of us as public officials or employees, have a general duty to act ethically and consistent with fiduciary duties. You must conduct yourselves ethically, honestly, and with integrity in all of your state bar dealings. You are fiduciaries, and as fiduciaries, you must exercise disinterested skill and undivided loyalty to the state bar in your work as trustees. Ultimately, you're working for the common good of all Californians and not for any private or personal interest. And relatedly, you must not use your state bar resources or office for private gain or any political or personal purposes. And finally, what we're really going to get into today is that you must avoid acting when there is any conflict of interest or potential conflict of interest present. A conflict of interest generally, we discussed that you owe a paramount duty of loyalty to the public in performing your public duties. And a conflict of interest occurs anytime you make a decision that is impacted or appears to be impacted by personal or private considerations of yourself or your loved ones or others in whom you have a private interest, rather than just and solely in the public interest. Each of you is personally responsible for disqualifying or recusing yourself from any decision making as a trustee when you have a conflict of interest. We generally talk about two different types of conflicts. One is a financial conflict, and that's what it sounds like. It occurs if you participate in a decision that is reasonably foreseeable to have an impact on your financial interests, whether that's immediately on your bank account, it's going to change what you're paying or earning, or on a source of your income, or on an investment of yours, or on a source of gifts to you. A personal conflict, it occurs when you participate in a decision where you might have a personal interest that may prevent you from applying your disinterested skill or loyalty. So some, decision that would, impact a close friend of yours in particular would be an example. The concept of personal conflicts includes appearances of conflict. A reasonable person would perceive a conflict. So even if you think, oh yeah, this is going to affect my friend, but I'm making my decision for other reasons. I'm not considering that. It's not a subjective standard like that. It's an objective standard. There's a conflict if a reasonable person would think you might not be disinterested. Aline touched on this, why avoiding conflicts of interest is important. We are held as public officials to a high standard of ethical conduct, and that public trust is essential for the agency
We did. Okay, I can pick it up and then he'll be back, so in the interest of time. So we did talk about the purposes for avoiding conflict of interest and why it's important, and it's particularly aligned. Go ahead, Brady.
I'm sorry, where did you, I all of a sudden Zoom just shut off and I got a message.
Yeah, it didn't make much headway. You can continue on where you live.
Have I been, I'm sorry, where was I, Aline, when I...
Okay, we were covering why avoiding conflict of interest is important, and
okay.
I was to mention that it is aligned with our mission and carrying out our mission in an appropriate way.
Okay, great. So I didn't get too far. That mission really, it's both the mission can't be fully accomplished if the public doesn't perceive the state bar as impartial. And I just realized I lost my share, so let me get that back up. This is Murphy's Law. I've never had trouble with these presentations to the board, and the one time. All right, can everybody see the screen now? Why is avoiding conflict of interest important?
Yes.
Okay. Just very briefly, this concept goes far back, even before the statutes we're going to talk about in the California common law. There's a leading case from 1928 that holds that a public officer is bound to exercise their public powers with disinterested skill, zeal, diligence, primarily for the benefit of the public. And the case goes on to say that it doesn't matter whether there's an actual injury. It doesn't matter whether the public official's decision is actually changed by their interest. The damage is done if they're making a decision when they have a conflict, because that erodes the public confidence. The concepts that we're going to talk about come from a lot of sources, including the Political Reform Act, which governs Form 700 filing and defines some of these financial interests we're going to talk about. Government Code Section 1090, which prevents you from entering as a state body any contracts that you have a financial interest in. The State Bar Act, which has our particular both financial and personal conflict recusal obligations. The Conflict of Interest Code for trustees of the State Bar of California, that is adopted by the Supreme Court, and it defines the actual types of financial interests that you need to disclose. And finally, State Bar Rule 2201, which is how you report connections and interests in individual lawyers, so that we can, as an organization, evaluate and potentially assign out to outside counsel particular discipline matters to avoid conflicts or appearances. Jumping straight into the State Bar Act, Financial Business and Professions Code Section 6036A and the Conflict of Interest Code is where our financial recusal obligations come from. Business and Professions Code 6036A states that you must disqualify yourself from making, participating in the making of, or attempting to influence any decision that will have a reasonably foreseeable material effect, distinct from its effect on the public generally, on your financial interests. So when a decision comes before the board, or you're having discussion with State Bar staff about something that's going to be coming up, you need to think about whether whatever this decision is reasonably foreseeable to have an impact on you, your sources of income, any investments that you might have, any financial impact on you, different than from everybody else. So an example of that, distinct from its effect on the public generally, a lot of you are lawyers. We vote on, take positions on fees that will be applicable to all lawyers. Well, because it has the same effect on all lawyers, you're allowed to vote on that, setting aside that small changes in fees are probably not going to be material ultimately. Financial interests that you might have and that you need to consider whether they're affected by our decisions include, both direct impact on your bank account, but also an impact on your sources of income, impact on people or agencies or organizations that have given you gifts, and any impact on, your real property or anything like that. Your financial interests generally include the financial interests of your spouse or registered domestic partner, as well as any dependents. Materiality is ultimately a fact-sensitive, fact-intensive inquiry. There are various regulations published by the FPPC that talk about how you determine materiality in any circumstance, and we can help you work through those. But ultimately, our ask is if you see a decision that you think could impact you or your financial interests, your sources of income, raise that to us so that we can help you work out whether that's something that's material or immaterial, such that recusal is or is not necessary. And as I mentioned, that limitation that you only need to recuse yourself if the financial effect is distinguishable from the effect on the public generally. That generally means that trustees who are licensees don't need to recuse themselves from a decision that affects all licensees equally. So it's really more if there's a special impact on you or your law firm, or a certain type of law firm, perhaps would be an effect that's distinct. Moving on to Business and Professions Code Section 6036B, this is the provision for disqualification based on personal conflicts. And that section states that you must disqualify yourself from making, participating in the making of, or attempting to influence any state bar decision where there exists a personal interest that may prevent you from applying disinterested skill and undivided loyalty to the State Bar in making or participating in that decision. This statute was amended several years ago to extend to perceived conflicts. That may, it used to be will. So now it's an objective standard. It doesn't matter whether you think, oh, I have a close relationship with the person who's going to be affected by this, or, I have a, very strong public opinion I've issued on this, issue before I came to the State Bar, but I'm not going to let that affect my judgment here. That doesn't matter anymore. It's really whether a reasonable person looking at this would think that that your decision making would be impacted by a personal interest outside of your State Bar work. So again, if you have any connection, pre-existing connection, a personal impact to a decision or issue that comes before, we encourage you to reach out to us so we can figure out under this objective standard whether it's something that you should recuse yourself from. There are some guidelines and principles that we apply to making that determination. One is if a decision is going to have an impact distinct from the impact on the public generally, on you personally, or any person with whom you have with whom you currently have or in the past 12 months have had a personal or professional relationship. You have a personal relationship if you are relatives, or there's another relationship of a nature that could be perceived as a reasonable person as personal and potentially affecting your ability to act impartially with respect to that person. So close friends. Impact on such a person could be financial or another benefit or burden to them that could trigger a personal conflict for you. You have a professional relationship with a person if you currently or within the previous 12 months were an employer or coworker of a person, if you represented that person or are a member of a firm or entity that represented that person, if you are represented by a person or a firm in which that person is a member, or you have another relationship of nature that could be perceived by a reasonable person as professional and potentially affecting the individual's ability to act impartially with respect to the person. So this concept covers your, close business and professional relationships. Moving on to contracts, covered individuals, which includes State Bar trustees, shall not be financially interested in any contract made by them in their official capacity or by any board or body of which you are members. And ultimately, the board of the State Bar, as a matter of law, is considered and deemed to be the entity that enters into all of the State Bar's contracts. So we need to evaluate all of the contracts that the State Bar signs against your financial interest to determine if you have a financial interest in them, so that you can, recuse yourself from that decision. In certain instances, your relationship could be so close that the State Bar would be precluded from entering into such a contract. But generally, as members of the board, a conflict of that nature could be resolved by you recusing yourself from participation in deciding to enter the contract or ratifying the contract. This is a real concrete example of why it's important that you, fully fill out your conflict, your Form 700s, and we're going to talk about the mechanics of that soon, because we look at the, various entities that you list on those Form 700s, and then when, we look at the contract item that comes before the board, almost every item, over almost every meeting, we're checking that against the companies that you have reported an interest in, so that we can help you issue spot this and avoid these kind of conflicts. Just briefly, we've never had to get to this with board members since I've been here the last 8 years, but violations of conflict of interest laws and policies can carry serious consequences. Those could include personal fines levied on you by the FPPC into the thousands of dollars. If you're a licensee, there could be professional discipline for willful violation of these rules. You could be disqualified from holding public office. In certain circumstances, it could be a misdemeanor or even a felony, depending on the actual conduct for intentional violation of these rules. reputational harm to the trustee and the state bar would occur if you are acting with a conflict of interest. There could be required invalidation of state bar contracts if we entered into a contract wherein board members had a certain type of financial interest. And as we'll discuss, the board itself has the option of admonishing, sanctioning, or censuring its members for failing to follow these rules. I want to talk a bit about the concept of gifts. Gifts are financial interests that are subject to disclosure. A gift is a payment or other benefit that confers a personal benefit to you where you do not provide equal value in return. The concept of reportable gifts is subject to a lot of exceptions, including gifts from close family members, reciprocal exchanges of gifts of similar value on birthdays or holidays, and even gifts from personal friends, as long as your relationship with a personal friend has no connection to your work as a state bar board member. All of those are exceptions from the concept of a gift that would be reportable and that would be a financial interest. So really what this concept's getting is gifts that either may be or may be seen as attempts to curry favor or influence with you as a public official. So with that in mind, and so that would include, gifts from law firms would be a great example, or gifts from attorneys who are not a close personal friend of yours would be a great example of the kind of gift that would be reportable and potentially a disqualifying financial interest. Gifts aggregating $50 or more in a single year from a single source in the disclosure categories listed in your conflict of interest code. And just as a preview, that includes any lawyers, any law students, anybody involved in the California legal industry, and any business that does business with the state bar or is of the type of business that could do business with the state bar. Any of those things are reportable sources under your conflict of interest code and on your Form 700. And so if you get gifts from any company like that or anybody who works in a company like that, you need to report such gifts. Additionally, you may not receive any gift of more than $630 from any sources in your disclosure categories. Again, that prohibition on the $630 only applies to gifts as a term of art, and that term of art excludes gifts from family members, gifts from personal friends where you have a relationship that is independent of your work as a public official. So again, it's just the type of gift that could be seen as influence peddling or an attempt to curry favor. An additional prohibition on public officials, including trustees, is that they may not accept honoraria for speeches, articles, or event attendance from a source that's reportable on your Form 700. So again, that's the California legal industry completely, and any type of business that does business with the state bar or is engaged in a business that could do business with the state bar. There is an exception for income earned in connection with customary services in your business, basically. So if it's your business to give speeches and make presentations, there's no bar on that. It's more, again, getting at these influence peddling. Oh, we've got this member of the state bar, and we're having them in, and we're going to pay them a lot to give a speech. That's what it's getting at. Trustees also may not receive personal loans from any officer, employee, trustee, consultant, or contractor of the state bar. That's subject to exceptions, including for commercial loans and credit card transactions, so long as they're made in the lender's regular course of business on the same terms that any member of the public could do business with them. So one of the key steps in of addressing and avoiding conflicts is the concept of disclosure. Potential sources of conflict are disclosed through your Form 700 filings, and that's disclosure of your financial conflicts. Those, as we're going to discuss, happen when you start, and then every year as a trustee, and then when you leave. And those are public documents. They are posted on our internet, so we'll keep that in mind when we encourage you to use your state bar address rather than your home address for contact information. And also through the Rule 2201 Conflict of Interest form, which helps to identify financial and personal conflicts with attorneys. This disclosure increases transparency for the public, and it also helps trustees and also employees who are subject to these codes identify potential conflicts before they occur. Additionally, where there exists a conflict, you need to disqualify yourself from decision making. So that would include outside of bar meetings, if you're on some sort of working group or task force or assigned with discussing something with state bar staff, you would just cease those communications. But as far as items that actually come before the board at a board meeting, you should not participate in any discussion by the board of such an item. And then when the vote comes up, you would disclose that you have a financial or personal interest, and say that you abstain for that reason. You don't need to go into any detail at a public meeting about what the interest is, just that you have a financial or personal interest and are abstaining from the decision making for that reason. So as Aline mentioned, and as I mentioned earlier, everything we're discussing here is ultimately a personal responsibility of each individual public official. Trustees are responsible for determining if they have a disqualifying conflict and to disqualify themselves where there is one. We are here in the Office of General Counsel to answer any questions, and based on the information that you've given us, we will do our best to also help you do the issue spotting, and we review agendas and we'll reach out to you if we see something. But ultimately, it is a personal responsibility. However, if the decision to disqualify is ultimately yours. We can give advice as attorneys. However, if facts indicating existence of a conflict are brought to our attention, either we know them or it's something that you told us, and we advise disqualification, it's generally expected that you would comply with that advice for disqualification. If you don't, and this is all in the board policy manual, the general counsel will inform the board as appropriate, and any trustee on the board may move to preclude the trustee from participating in a board decision by motion. The impacted trustee and the general counsel may both speak on the motion. The impacted trustee could explain why they don't want to disqualify themselves. The general counsel could speak on why disclosure is advised. And then there will be a vote on the motion on which the impacted trustee may not vote. And ultimately, if the board votes to the impacted trustee shall be disqualified, they shall then recuse themselves and not vote on the matter at issue. The board policy manual also provides for enforcement actions by the board if a trustee is accused of violating any ethics or conflicts of interest laws or regulations, as discussed here and set forth in the board policy manual. The procedures therein include notice and an opportunity to be heard by the impacted trustee, with greater process provided for more severe actions. If there are any allegations of misconduct by a trustee, they shall be made under this policy to the chair and/or the vice chair, or if they are the subject of the allegation, to the executive director and/or general counsel. The executive director and/or general counsel will take appropriate steps to review, investigate, and recommend a course of action. The actions that the board could then undertake could be no action if there's a determination that there was no violation. It could be an admonition. This is the least severe action, and what that typically would be an action by the board, a statement, and it would be typically directed at all trustees, reminding them that there's a particular type of conduct is in violation of applicable law or regulations. A sanction, next level of severity, would be a board action and statement directed to a particular trustee based on particular conduct determined to be in violation of applicable law or regulations, but that's not considered punishment. Finally, the board could move towards censure, which is the most severe form of action available to the board. It's used for serious offenses. It may be combined with loss of committee assignments or a referral to the authority that appointed the trustee, so the Supreme Court, the governor, the legislature, along with the recommendation that the trustee be removed from the board. A censure requires a separately noticed hearing, so that would occur over the course of there would be a notice board meeting at which the decision to move forward with the censure would occur, and then there would be a separate hearing to determine whether the trustee should be censured. Again, we formalized these policies with the board policy manual within the past couple of years, and none of these have ever come to pass. As we discussed, and just wanted to highlight again, it is each trustee's responsibility to follow ethics and conflict of interest laws and regulations. Liability for violations like the civil fines, et cetera, that I mentioned, ultimately fall on the trustees as individuals. Trustees should review all agenda items for board and committee meetings in advance and consider whether they have connections to individuals or entities mentioned in the items or that would likely be affected by a decision on the item. And the Office of General Counsel is available to provide information and advice for any questions. And as I said, we are also, based on what you've told us, looking at these and seeing if anything jumps out for discussion as to potential recusal. When to seek advice. So trustees should meet with OGC shortly after taking office to discuss potential sources of conflict. And trustees are also encouraged to contact OGC to discuss any changed circumstances that could give rise to conflict, new employers, positions, or responsibilities, new membership or roles in professional associations or other nonprofits, new volunteer roles or activities, also instances in which a person with whom a trustee has a personal or professional relationship is or may be involved in state bar purposes. Those are all circumstances that could give rise to a conflict, and we'd encourage you to contact us with those. We can have privileged communications with you. We have in the past sent questionnaires to you so we can get a better sense of the universe of potential conflicts that might come up in the future that we should be on the lookout for outside of what you report on the public Form 700s and Rule 2201s. And we will continue to have that outreach with you so that we can assist and help you think about what might come up for your self-identification. The final part of this training will be a preview of the Form 700 filing or review. I guess all of you have done at least one. You're assuming office forms for the newest trustees. And the next form will be due April 1st. So this is the Form 700, how we as public employees and you and trustees report your financial interests. Why does it matter? All the same reasons that all of this matters. It provides greater transparency to the public. It is required by the Conflict of Interest Code, which has the force of law. It reminds officials of the existence of these potential financial conflicts because, if you've reported on your Form 700 and then it comes up in a decision, it's going to be easy to notice, hey, that's something I need to pay attention to and might require recusal. And finally, failure to file your forms must result if after repeated warnings of the lateness ultimately needs to lead to a referral to the FPPC for enforcement. So it is important to get these in. There's three different types of Form 700s. One is the annual form. It covers the prior calendar year, and it's due April 1st. So this year you'll be reporting on this April 1st, you'll be reporting on your interest in 2025. Also, when you join, you file an assuming office Form 700 that covers the year prior to when you start as a trustee, and that's due within 30 days of when you started. And then when you leave, you will need to file a leaving office form within 30 days of leaving, and that covers basically the period since your last annual Form 700, generally January 1st of the current year through the date you leave. Just as a step-by-step of how you will handle your Form 700 annual statement, which should be coming out to you in the next couple weeks. Read or review the Conflict of Interest Code for the Board of Trustees of the State Bar of California. There haven't actually been updates to that code for about 2 years, but it is important to review it every year. by filing your Form 700, that includes a certification that you have read the code. There are some links here with FPPC puts forth several documents that are very helpful for answering any questions about how to file the forms, how to fill out the Form 700 and what should be included. There's an instruction document, a reference pamphlet, an FAQ document, and what's really useful when you're thinking about gifts is a fact sheet on gifts, honoraria, travel, and loans, and that describes all of the potential exemptions and exceptions to the gift concept in detail. There are also instructional videos on the FPPC website. Next thing, and I think the most important part of the Conflict of Interest Code to review every year as you're doing your Form 700 is your disclosure categories, and those are in Appendix B of the Conflict of Interest Code. We are going to go over each of those 3 disclosure categories in a minute. When you fill out this Form 700 annual statement, you must disclose any financial interests that you or your dependents had in calendar year 2025, including your community property share of your spouse's income, that fall into any of your disclosure categories, any of the 3 disclosure categories for trustees. Once you've identified the financial interests that you're required to disclose, you'll be ready to complete and file your Form 700 using NetFile, which is the State Bar of California's e-filing system. Instructions with links should be going out probably within the next week. To review your disclosure categories, as I mentioned, those are in Appendix B of the code. There are 3 categories. The first category that you need to report is all reportable interests in real property located in California or within 2 miles of California. So this is your property holdings. There is a major exception for your house, your personal residence, which is your primary personal residence, and any other personal residence you might own as long as you're not using it as a source of income for rental or as a business tax deduction as long as you're not using it as a place of business. So those are the primary exceptions, but other than that, if you own real property, that is something that you will report under Category 1. Category 2 is essentially the California legal industry. This is all reportable investments in sources of income received from or positions held in any persons or entities that are subject to the regulatory or licensing authority of the State Bar of California or have an application pending before the State Bar of California. So that includes California attorneys and law firms, including, but not limited to, limited law corporations and limited liability partnerships, law schools, law students, applicants to become licensed by the State Bar, lawyer referral services, legal aid providers, providers of mandatory continuing legal education in California, and financial institutions offering IOLTA accounts in California. These are all people or entities regulated or are applying to be regulated by the State Bar. As such, they have a clear connection to the State Bar, and you need to report your financial interests in those. And finally, Category 3 is all reportable investments in sources of income received from or positions held in businesses that are located or do business in California and that manufacture, provide, or sell in California goods, services, supplies, materials, machinery, or equipment of a type purchased or leased by the State Bar of California, including without limitation, and its legal services, legal publications, office supply vendors, travel agencies, insurance companies, banks, IT vendors, providers of consulting concerning the prevention or rehabilitation of persons suffering from chemical dependency, media management companies, real estate brokerage firms, employee benefits providers, and those are the categories that we've listed because these are the types of vendors that we do business with on a regular basis. Essentially, what the purpose of this category is to have you disclose any financial interest in, and that means investment in, income from, position in any type of business that either currently does or could do business with the State Bar. When we send out the Form 700 instructions, we have another document that sort of gives some more examples here and examples of the kinds of things that would not be in Category 3. So we don't ever engage and are not we don't engage with defense contractors. We don't engage with a biotech research company. So if a financial interest is in a business that has nothing to do with anything that the state bar would ever purchase, that's not going to be reportable. But if it's one of these enumerated categories or the type of company that the state bar could conceivably do business with, then that should be reported in category 3. So for each of these categories, we've talked about sort of how what you report on your Form 700 is limited by those categories, sort of by the type of business that something is in. But there are also sort of some thresholds for what is reportable generally, setting aside what industry it's in. So first of all, we've talked about how you need to report real property or investments in various types of business. Well, there's a threshold there. You only need to report investments valued at $2,000 or more at any point during the reporting period. So if you have a tiny investment, that's not going to be reportable no matter what industry it's in. There's some general exceptions to what is a reportable investment. Bank accounts, government pensions, and many types of diversified mutual funds are not reportable at all. Just to speak for a moment on diversified mutual funds, and if you have questions about them in particular, we can help you work through those. But in general, if a mutual fund has multiple investments in multiple companies and is not targeted at a specific industry, and you have no say in what particular investments are made by that mutual fund, then that's considered a diversified mutual fund, and you wouldn't need to report your holdings in that, even if one of the many companies it happened to hold stock in was something that would be reportable. Excuse me. Sources of income, again, the Conflict of Interest Code disclosure categories require you to report sources of income if they are from the California legal industry, category 2, or from a type of business that could do business with the state bar. However, it's only reportable at all if it's income of at least $500 or more during the reporting period. Government income is a major exception. It's not reported at all. Sources of gifts we've spoken about. So gifts totaling $50 or more during the reporting period, if they're from one of those sources in categories 2 or 3, would need to be reported. And finally, setting aside whether you actually get remuneration. If you have a business position, if you're a director, officer, partner, trustee, or employee, hold a position of management in a business that is engaged in the legal industry, or the type of business in California that the state bar does business with, you would need to report that even if your position is uncompensated. So just to reiterate the concept, you need to only report financial interests on your Form 700 if they're reportable generally. So they investment of over $2,000, income of over $500, gift of over $50 that don't fall within any of those, general exceptions, government income, so on and so forth. So if they're reportable generally, and they fall within one of the 3 disclosure categories for trustees. Just to circle back, there are some financial interests of your immediate family that are reportable. Investments in real estates held by your spouse, registered domestic partner, or dependent children is reportable as if it's held by you. Income received by dependent children is reportable just as if you were the one getting paid. And as for income of your spouse or registered domestic partner, you report 50%, your 50% community property share of that income. Gifts to immediate family, so gifts received by your spouse or your dependent child are not reportable as gifts if the source of the gift had an established relationship with your family member and there's no evidence that gift was given to your child or your spouse with a purpose to influence you. Of note to people who might own businesses, or be partners of firms. There are some very limited instances where individual sources of income to a trustee's or their spouse, registered domestic partner, or domestic child's business or employers may be required to be disclosed on Form 700s. So first of all, that only occurs if that individual source of income falls within one of your disclosure categories. So if you own a plumbing business, you might have to report individual sources of income to that plumbing business if that source of income falls within one of the three disclosure categories. So is part of the California legal industry or is the type of business that does business with the state bar. Now, that reporting of an individual source is generally required if you or your spouse, registered domestic child, or partner owns more than 10% of a business, and you or your child's or your spouse's pro rata share of the income from that single source is $10,000 or more. So if you own 10% or more of a law firm, and your pro rata share of income from a single client is $10,000 or more, then you would need to report that source of income if that source of income was in a disclosure category 2 or 3 of the Board of Trustees. Less common in our experience here with trustees is that if you or your spouse, registered domestic partner, or child is a broker, agent, or salesperson and receives $500 or more in commission income due to a sale to a single source, then that source would be reportable if they fall within one of our disclosure categories. And finally, if you, the trustee, or your spouse, registered domestic partner, or child received incentive income of $500 or more from your employer based on a sale to a single source, and you or your spouse or registered domestic partner had direct personal contact with that single source intended to generate the sale for which you were receiving incentive income, then you would need to report that single source if they are a reportable source. So that's a lot of detail, and it won't be applicable to all of you, but just wanted you to be aware that there are certain situations where a single source of income to your employer or to the business that you own might be reportable, even though that customer is not the one directly writing you personally a check. It's going through your employer or your the business that you own. And again, I don't expect you to remember the details of this, just to sort of spot it as an issue when you're thinking about what you might need to be disclosed. I mentioned reporting of clients of law firms. There is a provision of the Conflict Interest Code that sets forth a procedure for claiming privilege as to disclosures that would otherwise be required. So once you've identified the financial interests, if any, that you'll need to report, you're ready to file your Form 700 via NetFile. Again, I need to double check with HR. We did this a little earlier than the training last year as to when it will be available to send out to you. But I think it'll be in the next couple of weeks, and we will reach out to you about that. All trustees must complete the cover page. That's the first page of the Form 700, and the schedules, which are the separate pages on which you'd report your sources of income, your real estate, any gifts that are reportable, must be completed only if there are financial interests to report. But page 1 is a must. If you have nothing to report, there's a box where you'll check nothing to report. A few tips on filling out that first page. The jurisdiction of our office is state, so you want to check that box. You'll be doing an annual statement covering January 1st through December 31st, 2025, unless you started your position in 2025, in which case it'll cover your starting date through December 31st. And the best practice is to use your state bar contact information, not your personal contact information, as Form 700s are public documents, and it will be posted on the internet. So please bear that in mind. And finally, Aline and I, as on every topic, are available to discuss and advise on any ethics or conflicts-related questions or concerns. FPPC, as I linked in the earlier slide, and also here, have some really useful online resources, as does Section 11 of the Board of Trustees Policy Manual, provides an overview as well as links there. And that's it. So I'm available for any questions.
Thank you, Brady. Very comprehensive. Thank you to you and Eileen. Are there any questions?
I have a question.
Please go ahead.
So I guess I have more of a procedural question. If we identify a conflict and it goes, the issue comes before the board, is it the when they say you can't participate, is it the better practice to leave the meeting, or can you still stay in the meeting? And then, as far as the terminology when the vote happens, is it abstain? Is it recuse? Is it disqualify? What's the language that needs to be said?
Great questions. Recusal would be the more appropriate. If you are disqualifying yourself due to a personal financial conflict, under the board policy manual, the appropriate verbiage is recusal. However, there are instances where it may be on the cusp and you don't have to, but you still choose to not participate in the vote out of abundance of caution, then our board policy manual allows you to abstain. So if it's a recusal for conflicts, then it would be recusal. But if you don't have to recuse, but you're still choosing to do that, abstention is fine. To answer your prior question, there are, and maybe it's coming from your role in the city, world, there are specific statutory requirements that apply to certain types of filers that are statutory filers, and those are council members, mayors, city attorneys, etc. And there's a specific provision that applies to them that if there is a, requirement to recuse, they have to step out of the meeting.
Mm-hmm.
That same requirement does not apply to the state bar because we are code filers. However, a board member has, the ability to do that if they wish to. And obviously, if it's a matter that is a closed session matter that there is a recusal for, then you would obviously need to step out from that discussion and not participate.
Thank you.
I don't know, Brady, if you had anything else to add.
No, that was. I would just say on the vote count is affected the same way with recusal and abstention. So don't. Aline is 100% correct on the terminology, but it's the important thing is that you do one or the other, whether you get the word right or not. It doesn't affect the way the votes are counted or anything like that.
Yes, Trustee Sowell.
From a clarity standpoint in terms of participation, kind of piggybacking on Ray's question, participation does not just confine itself to the when the item comes up in the meeting, correct? It means you can't talk to board members about it or at all.
Correct. Influencing a decision on which you might have a personal or financial conflict would be inappropriate.
Okay. I do think I need to talk to you and Brady about some work that my nonprofit is doing, where we've started to interact with board staff, what I think the team is aware of. So I wanted to just make sure I get a little bit of clarity on that. There's no sort of financial interest in it or whatnot, but I just want to make sure how I proceed there. And we can do that at another point in time. And then if you wouldn't mind just reminding me and the board, based on some of the things that have happened over the course of our history, in particular with things that happened with Girardi, et cetera, the Form 700 requirements now are expanded to not only just to more members of the board's, more board staff. And so could you just sort of speak to
The reforms.
Yeah, the reforms.
Sure.
Thanks.
There were a number of what we call conflict of interest reforms that were enacted in the wake of the report that came out by Helper Maine highlighting some concerns with the handling of the cases against now disbarred attorney Tom Girardi. So a couple of things that happened. One, the conflict of interest code for the board had not been updated for a number of years. So the board updated the conflict of interest code to bring it sort of up to par with how other public agencies are reporting for boards. And then there were a number of legislative amendments that the board prioritized and advanced, including the changes that Brady talked about with respect to personal conflicts, changing it from the will to may standard, which in essence codifies the common law conflict of interest. We submitted the conflict of interest code to the Supreme Court, and they also gave us a directive to update the code. The code for the staff had existed, Trustee Sowell, but we revisited that, make sure that the disclosure requirements align with the responsibilities of the position, so that the disclosure requirements are aligned with the decision-making authority of those individuals or those positions. The disclosure requirements for the board were definitely expanded. One of the other initiatives was expanding the enforcement mechanisms that are available under the board policy manual, and Brady spoke about that, the admonition, the censure, the ability to enforce and take a motion to prevent somebody from participating in a decision that may be conflicted. So those were all part of the reforms that were enacted by the State Bar with the leadership of the State Bar Board of Trustees, the Oversight Committee that we had at that time, and obviously my office and others involved. Oh, and one more, we have a transparency website. The Form 700s are also now posted on, for the board, are posted on our website. And the compliance statistics for that, as well as the 2201 questionnaire disclosures, are also now routinely reported on our website. And it's a little, not connected but related. We also instituted the whistleblower program. This through our DOJ program, California DOJ. So if there are any concerns that come in pertaining to those issues, those go and are routed directly to the DOJ for review.
Anyone else?
I just want to say thank you for you and Brady for the report and for the training.
Sure. Trustee Tony.
Thank you. I want to echo Trustee Soule's thanks to Brady and Eileen for this really informative presentation on conflicts. I do have a few questions. I really appreciated the clarification about what recusal means. It means not only during the vote, but it means during the discussion. It also means outside of the meeting. You shouldn't have discussions with, even within Bagley-Keene, you shouldn't have discussions about that issue. So I appreciate that clarity. And I guess my question has to do with the timing of the disclosure. Sometimes we, will have a discussion on a topic, and the first time we hear that there's a conflict, the other trustees, is when the vote is being called. I'm recusing due to a conflict. Now, I'm kind of mixed about the issue of, well, should you disclose why? My opinion is that you should, but that's kind of unclear. I've also heard say that you don't. One of the things I'd like to feel assured and would like trustees to do is that when you have something that you think either you definitely know you're going to recuse yourself on because you're following the rules, that we all have an obligation to let the general counsel know at least ahead of time, okay, before the meeting, before the vote. And if that if I had that kind of assurance, then I'd be okay without, in public saying exactly, all the details, okay? And the reason is because I'm going back to, there's a slide called Contracts Government Code 1090. And it says, if one trustee has a financial interest, the state bar cannot enter into the contract. That's what it says. Now, how are we going to know? But then we would have to know that a trustee has a financial interest. And if all we hear is, I'm recusing myself, and we get no other information, I don't know how to comply with the government code. So that's kind of a general question. I'm trying to piece things together here.
Advance notice is always welcome by my office because a lot of times it's, fact-intensive analysis. But I would say typically, in my experience, I get a heads up from the trustee, or it might be at our device that they're recusing themselves. And if it's around the contract issue, then Brady and I would probably caucus really quickly. And if there is a concern, would suggest pulling the item, until further analysis is done. So, but yes, to the extent trustees are able to flag those issues for us earlier, that would be, extremely helpful to our analysis and getting a process in place for moving forward. And that's why in our communications to you, we also include the conflicts reminders, particularly prior to the board meetings, that please take a look at the names, the vendors, et cetera. If anyone pops out to you, please reach out to us.
Thank you. I have taken advantage of myself of going to the Office of General Counsel and asking for advice and asking for their guidance because I don't always know this stuff. How is the issue treated? I don't know if you call it gifts, but we'll call it gifts for now, among trustees. So let me give a scenario. Let's say that I decide that it would be good for me and as the chair of the audit committee to have a quarterly lunch with the vice chair of the audit committee, just for instance, okay? And we say, we'll take turns covering lunch, okay? We don't want to hassle the servers and stuff, okay? Just a little thing. Now, two people lunch in San Francisco is going to be over $50 when you have the tip and the interest and, taxes and stuff. If we, in that scenario, would we be required to report each of us that we had gotten the value of over $50 for lunch together among colleagues? So I'm just asking.
So there, the devil's always in going to the gift fact sheet. First of all, no gift, nothing from you, Vice Chair, would be reportable because you are not an attorney or engaged in a business with which the state bar does business. So you're not a reportable source to begin with. However, there is an exception to the whole gift concept for reciprocal gift exchanges of reasonably the same value. So if you're going back and forth on who's paying for lunch, that's a reciprocal exchange.
But I'll put my conservative hat on, and to the extent you can just split the lunches, that's probably more advisable.
Okay. Thank you very much. I think the only other thing just to add is first of all, since I've joined, we've had a lot of progress on conflicts of interest, both in terms of what's included, so that it used to be limited to financial, and it used to be limited to material interests and not optics, not the perception. And I think it's much, much better now. I also appreciate that we do these trainings in person now instead of each individual trustee going to a website and watching a video. This is much, I think, much better. People can ask questions. And then I also like the fact that we now have a practice where all of us have to fill out a form saying all the attorneys that we have a relationship with, that we pay, that pay out, whatever is, so I put all the names of the attorneys that work at my organization, and all of our consultants who are attorneys. And so that then if anything came up in terms of a complaint against them, it goes to the special deputy unit. And that's part of conflict of interest. That's why I just want to bring it up. So I really want to thank the Office of General Counsel has really taken the lead on this, and also all of the Board of Trustee leadership who has supported this. Thank you.
Thank you, Trustee Tony. Any other questions?
Trustee Harrison.
Yes, go ahead, Trustee.
So I have a question. I have represented a couple law firms, a few attorneys, and I'm also the liaison to the conflict of interest unit that handles those conflict disciplinary investigations. What happens if one of the attorneys that I've represented has a complaint against them and it goes to that conflict of interest unit and I'm supposed to be the trustee that's tasked with overseeing it?
If it's a matter that it pertains to an attorney that you put on your 2201 disclosure, I think you need to flag it for Stacia and flag it for us. And I think that's something that you would recuse yourself from.
Okay, thanks. It hasn't happened. I was just curious. It just a thought.
Yeah. Good question.
As we can see, it's a very complicated and comprehensive topic, and I'm glad we're spending this amount of time on it, and we should often. Any other questions? All right. Thank you, Eileen and Brady. Obviously, you both are available going forward if anyone comes up with any questions or situations later on they want to be advised on. And with that, we'll move on.
Just real quick.
Yes.
So we'll be getting the forms to fill out in the when?
I don't have the exact time frame, but we usually try to get them out the first or second week of February. So those will be coming your way, and we're also going to be sending you the additional, conflict of interest questionnaire that OGC does. So that should be forthcoming in the next few weeks.
All right, next is item 5.2, State Bar Financial Overview and Discussion on Collections and Exploring Funding Opportunities. And we are...
I think we're doing the communications.
Oh, sorry. All right. Overview of Strategic Communications and Stakeholder Engagement. All right. Jorge and Rick Coca, come on up, folks. Welcome.
Good morning, trustees.
Thank you. Glad to be here.
Hey, good morning. My name is Jorge Descaide. I am the Program Director for the Office of Strategic Communications and Stakeholder Engagement. And joining me today is Rick Coca. He's a Program Manager in the office, and he also serves as our Public Information Officer. So today we're going to provide you with an overview of the purpose and scope of work of our communications office. We want to spend a few minutes to provide you with some updates on some recent strategic initiatives that our office has led over the last couple of years. And then we're going to discuss our media inquiry protocols and your role as a trustee in case you receive an inquiry. And then we'll close the presentation with just summarizing our office's 2026 objectives. So our office really serves as a central hub for information flow within the State Bar to communicate to the public, licensees, and other key stakeholders. We lead transparent and effective communications to build trust and awareness by managing the public websites, the website's content, our social media channels, to make information accessible. We also strategically engage with members of the media, and we conduct public outreach to make important information available in a timely manner. We partner with State Bar executives, our leadership team, and members of the various offices to create and disseminate strategic communications. Some examples are disciplinary actions, information around licensing and compliance, information about the bar exams, responses to the media, and we also provide information on updates on strategic initiatives that are run by the various offices. And so all the work that we do is in alignment with Goal 4 of the strategic plan. So this is just a visual representation of the various areas of responsibilities, which we'll cover in more detail on the following slides. I just want to note that we have a staff of 7 that support the work across all of these areas. So as you know, in December, we went live with our new public websites. This was one of the top priorities for the office and for the organization last year, and the effort aligns with Goal 5 of the strategic plan. The sites are really our critical communication channel. They are the front door in the digital space to the members of the public and every other stakeholder. If you can see, last year we had 13 million page views across these 2 websites, and the staff also completed approximately 1,900 web content inquiries that we received from staff alone. So the websites themselves are, very large. We have over 5,000 different web pages and documents on our websites. So this effort was quite complex due to the size of the websites. We did this over an 18-month period, working with multiple vendors. We gathered feedback from internal and external stakeholders using surveys and other communication methods that helped inform the designs for creating the new websites, which we've implemented on new technologies that replaced the old websites that were on outdated technologies that really made it very difficult for staff to maintain and update the website, its content, and it really limited our ability from taking advantage of some of the modern tools and features that you see on most websites today. So the goal was really to transform a functional but outdated web presence and create a dynamic, effective communication tool that makes it easier for us to display key information to members of the public and other audiences, and also making it easier for staff to manage the websites as we get inquiries from all the various offices, while ensuring that the websites are still safe, secure, that perform well, and are accessible. And so this launch that we did last December, this is just the first step to improving the overall web experience. We know that we still have much work to do. We've recognized that there are some issues with the launch, and so we are actively working on addressing some of these currently, but this is going to be an ongoing effort for us in the coming months to stabilize the sites and make the experience better for all. So just to recap a couple of the improvements that we made with the launch of the new websites, we've simplified the navigation menu and reorganized some of the content that makes the website easier to search for information. We've enhanced some of the key features on the website, like the website search to find information, but we also made the multilingual translator tool available on every single web page. On the last site, we were limited to doing that. We could only have the translator tool available only on a handful of pages because of some limitations with the technology. We also created a couple of new sections of the website, such as the Help Center, which is where you'd find a consolidated, frequently asked questions, which again, the intent is to make it easier for web visitors to find information in one place. We also built the sites to be on mobile friendly designs so that you can use these sites on any device, whether it's tablet or iPhone. And we wanted to make sure that as part of this project that we remain compliant with the Web Content Accessibility Guidelines. And so the sites are in compliant with version 2.1, those requirements. Now we know that, as I mentioned, we've have some things that we need to continue to do. One of the things that we did launch with the site is a new website survey, which is available. And this is a way for us to gather feedback from web users about their experience, what works well, what doesn't. And we review these daily so that we can identify and prioritize other ways to improve the website, which is something that, again, is going to be a continuing activity that we will do throughout the course of the year. In terms of the feedback results, we've received about 170 surveys so far since we launched last December. I would say overall the feedback is quite positive. One of the more common things that we are seeing are some minor issues with the website search, so we will be prioritizing fixing that in the coming weeks. Now we know that it takes time to get accustomed to using something new, right? The last website was launched in 2017, so people were using it for almost a decade before we launched this site, but we're confident that as people use the website more often, that they will find it also easier to use. Another important role of our office is our public awareness campaigns, which are aimed to increase awareness, educate, and build trust with the public. One of the things that we really try to do with these campaigns is target diverse communities where English is not the primary language. And so I'll put some examples up here in the slide. In 2023 and 2024, we ran 2 Spanish language campaigns in San Diego and in Fresno. And the goal here was really to help make the State Bar or establish the State Bar as a trusted resource for Spanish speakers who are seeking legal information. This was also an opportunity for us to establish benchmarks for our campaigns that would inform our future strategies. And so overall, we think that the results are very positive. When you compare the 2024 campaign to the 2023 campaign, we saw an increase in web engagement, we saw more activity on social media, and we saw an increase in Spanish calls to the contact center, right, for people who are asking for help. And we also saw a lower cost per click than when compared to the legal industry national benchmark. Cost per click is just a performance indicator that kind of shows if your campaigns are cost effective or not. The next series of campaigns that we did were focused on the lawyer referral services. We did this in 2024 and 2025. We ran 2 campaigns in English and Spanish to educate the public of the service and also drive people to the website to use the tool when they wanted to search for attorney referral services by legal specialty. You can search by geography or even preferred language. And the reason why we selected the LRS as a priority topic is because we got feedback from the Office of the Public Trust Liaison in 2023 that they were receiving a high volume of inquiries to the contact center with people calling for looking for an attorney. And so in conversations with them, we prioritized the LRS as a priority campaign to campaign on next. So this is what we did in 2024 and 2025. And again, if you look at some of the results, comparing the 2 campaigns, 2025 saw an increase in engagement on web and social media. We continue to see cost efficiencies. And so, again, this just begins to show you that, we're getting better and better in our campaign strategies and effectiveness. And so we continued the campaigns with the LRS, and we did one more at the end of 2025. But this time we focused on doing the campaigns in 2 markets. We focused on Los Angeles and Sacramento. Again, we did this in English and in Spanish to continue to bring awareness to the LRS and drive people to the website to use the tool. And so really in summary, when we look at all the results here, each successive campaign is built on previous learnings, resulting in really good, better audience targeting for our campaign strategies, more cost efficiencies from campaign to campaign, all while driving public awareness of the state bar, our resources, and driving people to the website to get information. In 2026, we have 2 more campaigns planned. The first one we actually are planning to launch in the next couple of weeks. We're going to target a new audience. We have prioritized Filipino, Japanese, and Chinese audiences this time. And again, the idea here is to make people aware of the state bar and the importance of hiring a licensed attorney. We selected these 3 audiences for 2 reasons. One, because they have a very large population, adult population in California, but also in looking at the attorney usage index data, we saw that the Filipino and Japanese audiences actually had high attorney usage in 2025. So we use that metric as an indicator to prioritize these 3 audiences. And we think this mix is going to give us a nice balance between high engagement potential and overall audience scale for the campaign. Something that we're also doing different in this campaign is we're not doing a social media campaign. We're going to do programmatic advertising, which is something that we have not done before, but it was recommended to us by our advertising vendor. And this essentially just means that we're going to be putting our ads and content on multiple websites that are frequented by these communities. And that's going to help us to expand our reach, but also to maximize our cost efficiencies. One thing to note here also is the Filipino campaign. We're going to actually do that one in English because of their strong language preference, but we will do the Japanese and Chinese campaigns in their native languages. Later on this year, we want to do another campaign. This time we want to focus on the attorney complaint process. We want to educate the public on the process itself, what constitutes a viable complaint, how to file correctly, and what other options they may have besides submitting a complaint. And so the planning for this is going to start, I would say, in spring of this year for a Q3 or Q4 launch. And we're going to work with the Office of the Public Trust Liaison and the Chief Trial Counsel to get feedback from them that's going to help inform our overall strategy. Okay. So now I'm going to turn it over to Rick. He's going to walk us through the digital publication work that the office does, our social media, and media relations.
Great, thank you. Thank you. The comms team works with multiple offices and divisions at the State Bar to create digital content that showcases the important work that we're engaged in and the benefit of that work to the attorneys, applicants, and public that we serve. Just a few examples of this content include the digital annual report, which is an overview of the State Bar's work over the course of the calendar year. It includes OCTC's latest discipline and diversion efforts. We also highlight the grant funding that the State Bar gives out annually to legal aid organizations, as well as transparency and accountability efforts led by this board, including the conflicts of interest reforms that OGC and you all were just discussing. Within the annual report, we premiere State Bar Stories, which are video shorts that highlight the human impacts of the legal aid funding we provide. the importance of the Lawyer Assistance Program from the lawyer's perspective, Client Security Fund recipients thankful for the financial reimbursements they receive after losing money or property due to a California lawyer's theft or dishonest conduct. We hear people's personal journeys through State Bar Stories. We also send out multiple emails and surveys to attorneys on behalf of other offices, as well as the quarterly all licensee emails to more than 277,000 active and inactive attorneys each year. Our December 2025 email to licensees had a 33% open rate. 20 to 25% is considered good. 30% and above is excellent. Next slide, please. And of course, social media is another important tool that we use to engage followers on our initiatives, policy, and achievements. This includes sharing agenda items and opportunities to provide public comment, news pieces we are involved in, important compliance deadlines for attorneys, and how the public can avoid legal fraud, just to name a few. We have nearly doubled our social media followers over the past 5 years and now have 82,000 followers. We continue to surpass our annual social media growth goals with a 15% total growth among all platforms in 2025 and nearly 19% growth on LinkedIn, which is our largest social media platform. Next slide, please. So obviously, media relations helps the State Bar share its policy goals and implementation, helps us explain our complex structure and legal requirements, address crises, and build public trust. There are two primary ways we interact with members of the media. Proactive outreach, we send out news releases on board meetings, policy initiatives, unauthorized practice of law cases, and data reports, i.e. the diversity report card, and media advisories on newsworthy attorney discipline. The other way we interact with the media is responsive inquiries. We respond directly, obviously, to media inquiries. We share requests with the appropriate leadership and staff, including some of you here, and work with them on a response that is accurate and transparent while doing our best to meet reporters' deadlines. We also facilitate interviews with key State Bar leadership and reporters, work on opinion or advice pieces from the State Bar, like the series of pieces that have been running in the Daily Journal now and from the Division of Regulation about CTAP rules and compliances, including their advice recently on complying with new trust account compliance reviews, as well as interviews OCTC did recently in English and Spanish for the San Diego NBC Telemundo, Telemundo affiliates, giving advice to their viewers and how to interact with an attorney and what to expect once you hire an attorney. Next slide, please. So over 2024 and 2025, the comms team averaged about 15 media inquiries a week, which is a count of our responses to reporters. Even with the interest in the February 2025 bar exam, this is down from the peak year of 2023, which was about 30 inquiries a week. And 2023 was largely impacted by Tom Girardi and John Eastman news, both of which received vast coverage. And as we've shared previously, the State Bar's commitment to transparency and accountability includes its responsiveness to the media as well as its posts on social media. As newsrooms become more depleted and technology advances, journalists are called to do more and deliver stories faster with ever-tightening deadlines. They use social media to both source and promote their stories. Next slide, please. And now to the crux of it all, your role as a trustee. Next slide, please. So just as a reminder from the board policy manual, the only persons with standing authority to respond to inquiries made to the board or to make public statements on behalf of the board or the State Bar are the executive director, the chair, or their designees. Doing their due diligence, reporters on deadline will often reach out to multiple staff and/or board members and to us as the media team. This board policy simply helps us respond to these inquiries more efficiently and timely. Next slide, please. So any inquiry or contact from the media should also be referred to the executive director or their designee. Please forward those inquiries you receive to Laura Enterton Speed and to us at our media email, which is barcom with 2 M's at calbar.ca.gov, so we can coordinate a response with you. Now back to Jorge to close it out.
Thank you, Rick. So what do we have in 2026? Well, we have a few things that we have listed here. A lot of these we've just touched upon already during the course of the presentation, but we'll just go through them relatively quickly. Again, we have 2 public awareness campaigns that we want to do this year. We're going to continue to improve the website, evolve the content, add new features, just make the entire experience better for all. We also are going to migrate the State Bar's intranet site to SharePoint. Our current intranet site is built on an outdated custom tool, and so this is another opportunity for us to migrate the technology to SharePoint to make the intranet, or to make, the intranet serve as a more robust tool for information sharing, document management, and enhanced collaboration among staff. And as Rick just mentioned, we're going to continue to do, our stakeholder outreach. We'll continue to gather input from stakeholders. We'll continue to develop communications to put out to, licensees, members of the public, and other key stakeholders. Now, one thing that is not on the slide that I forgot to put on there, and it should be on there, is this year we're going to begin the planning for the State Bar's 100th year centennial celebration, which is next year. So that is another effort that we'll begin to plan with our leadership, and I can imagine that many of you will be involved in those conversations as well. So with that closes our presentation.
Thank you very much, gentlemen. And as one of the members, and I'm sure I share this with some others, it's been very exciting to be here during the recent year, where you have been kept busier probably than your office has ever been in its history. It's been quite a journey, but thank you very much for your help and guidance and management through this very, very active and at times volatile periods. Are there any questions for our speakers? Yes, Trustee Buenaventura.
Thank you, Mr. Chair. So, when we were having a lot of discussion and, talk about what happened with the last bar exam, there was a flurry of activity on Reddit. And so I guess my question, I think you need to be where, the communication is. And there was misinformation on Reddit about what we were doing and some of the things we were trying to accomplish. So are we actively in that space too?
Yeah, well, during that time period, a decision was made to go ahead and meet them where they were at that time, right? So primarily was admissions staff were responding directly to much of what was out there. Ultimately, the problem or the issue grew bigger than that. So they continued to communicate with them, but ultimately, we just had to right the ship, and I think that's the work that you all were doing and admissions and everybody else was doing. But yeah, when it's part of crisis communication is, communicate where it's happening. So that did occur, and then that generated more, media inquiries and coverage, which is fine. But yeah, it is part of a strategy is to meet the audience where they are in those kind of situations.
Okay, and then also I wanted to thank you for your reaching out to the Filipino community. There are a lot, and your strategy and your objective to go into that community, I think, is well worth it. So thank you.
Any other questions? Could we bring the remote trustees back up on the screen as well? Yes, Barahona.
Yes, thank you. Thank you, Jorge Rick. Have you considered, I suspect you have, one of those sort of chat bots, sort of the how can I help you function? I'm sure you have, but I didn't see it, and I know that can be somewhat helpful, I'm sure, complex to add.
Yes, absolutely. That is one of the things on our roadmap that we're going to be working with other offices within the State Bar. Obviously, we want to create a chatbot that serves the needs of our web users, but also of the State Bar itself. So you can imagine implementing a web chatbot that has a direct link to the contact center for a live chat, right? So that's just one example. But yes, we definitely have this on our roadmap, and we'll be evaluating that with other State Bar offices on how to implement something like that.
Yes, Trustee Grande.
Do we have something on the website that directs members of the public of who the appropriate, you were talking about the exec director, the chair being the ones to go to? Because one thing I see, especially because I'm involved in different bar associations, people will directly reach out to me to have conversations about agenda items, right? But I think if there was something is there something on the website that kind of tells people, hey, this is like the appropriate channel to reach out to for these things?
When you say these things, can you?
For example, some of the agenda items we have for tomorrow.
Yes, yeah. We do have a public meetings page that directs people to the tool that we use called One Meeting that has information on what's on the agenda and things of that nature. But perhaps this is an opportunity for us to maybe bring some of those key topics or key agenda items a little bit more kind of front and center on the public website. So it's more,
So maybe one thing I'm thinking of is like a frequently asked questions, because I think one of the public commenters today were expecting a response, right, during their public comment section. So it might be useful somewhere in there to say,
Sure.
What can you expect, so that people know.
Absolutely. Thank you for that feedback. Yeah, we'll take a look at that. And, obviously we do have a help center that we just created that is where we host all our frequently asked questions, and we'll definitely take that back and create something for those kinds of situations. Thank you.
Trustee Soho.
Comment in a question. Thank you for the presentation. I will tell you, you threw me a curveball because I went on the website, I think it was the middle of last week, and all of a sudden I was like, I wasn't expecting to be updated because I was so used to navigating the previous one. It took me a second to sort of figure out what I was doing, but I did find it, I think, more accessible, and I do like it just feels just a better feel to it, at least for me. I don't know how the other trustees feel, but for me it felt better. But you did throw me a curveball. Here's my question, and maybe this will be something that we discuss further in when we get into the strategic planning discussion. But we talked about some of the campaigns that we are going to be moving forward with, and it seems to me that as a part of our requirements to protect the public, that we should have additional information on our website related to folks that may be in the undocumented community and or others, as it relates to knowing your rights, as well as an ability to sort of direct them to areas where they can get legal help and legal support. And I did not notice that, and maybe that is something that we need to discuss in our strategic planning sort of session that we're going to have when we talk specifically about the strategic plan. But it feels to me like that is something that we should be obligated to do.
Thank you. We do have some information on there. Fortunately or unfortunately, it's not the first time that immigrants have been targeted, and so we've had earlier campaigns to do that and to have it on our website. Maybe we can discuss about how to make that more easier to find for the public. We have how to avoid fraud. We have a number of sort of consumer alert kind of material, but we can discuss as well about how we can highlight that a little more.
Anyone else?
I'd just like to wait for other people.
That's fine, sure, Trustee Tony.
I really think we've made huge strides in communication. So I really want to thank, I think it's far more disciplined than it used to be, and I think it shows. I think it's a big part of, making the state bar, on its, pathway to building its reputation. So thank you very much. And I just want to start by addressing a question that Trustee Grande brought up. I appreciate the clear guidance that when we're called by media, that we should direct it to the executive director, to the comms team. Okay, that's very clear. To have that, I've usually directed it to the chair, assuming they will then figure out who to direct it to. But I do think it's okay, though, for members of the public to contact trustees directly. Let us know what they think in terms of, taking their thoughts into consideration. My basic advice is, well, that's nice. Talk to the other trustees. Don't just talk to me about stuff, okay? You have a view, you want it considered. Thank you for letting me know. And talk to other people. But anyway, so I do have one website issue that I would love advice on a pathway to who to talk to. The piece of the website I use the most is the board packet part of the website. It has been so difficult. Every time it is a struggle to try to download these files, convert them into PDF. I just wish they were PDFs to start out with. I'm like, and then when you convert them to PDFs, the links no longer work. And it's like, and even opening them to figure out which ones have attachments, which ones don't have attachments, going through, click, 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 click. Either there's a jackpot and there's an attachment, or it's not. And then the labeling. It's like everyone who puts a topic on has their own labeling format. There's no rationality to what files are called. And I often have to rename the files just so that when I look at the name, I know what it is, instead of having to open every file to find out what it is. That's part of, so stuff like this, who do I go to make some suggestions on what would be easier for us volunteers? And I spend literally 2 hours per meeting just fighting before I get to read the things. And I want to reduce that 2 hours of fighting with the website.
So I'm actually going to take that one. You're free to bring comments to me. We can look at the things that you have just mentioned now, how to make them more accessible, easier to read or focus on. So if you have specific items in addition to what you just discussed, we're happy to take a look.
I appreciate it, Laura.
Thank you. Anyone else? If not, thank you, Jorge. Thank you, Rick. And we'll move on to our next item. Very informative. Now, the State Bar Financial Overview and Discussion on Collections and Exploring Funding Opportunities with Laura and Araceli.
Okay, so this is our next item on our strategic planning session, State Bar Financial Overview, Collections, and Exploring Funding Opportunities. And Araceli and I will be going over some different points, including background info on a State Bar budget, how it's funded, what our funding sources are, I'm sorry, I just got the clicker, apologies. What our funding sources are, the difference between what are general funds and what are funds that are special funds, what our current funding status is, preliminary projections for 2026, and then other funding considerations and exploring other funding opportunities. With that, I will turn it over to Araceli to get into some of the details.
Thank you, Laura. Good morning, Board of Trustees. My name is Araceli, and I want to, Laura, you're going to, it's okay. So first, I want to start off going through all of the funds that we have. Give me a second. All of the funds that the State Bar has and how all of the revenues come in. We have a total of, oftentimes, I get the question of how many funds do we have? How are these funds funded? So I know it's a lot of information in this one slide, but I wanted to try to keep all of our 11 funds in one slide. So I'm going to go through each one. And I don't have it in here, but I am also going to highlight where the reserves for each fund are. Another question that sometimes comes up of, can we use other funds to, at some point it was to help the general fund or help the admissions fund. So I did want to highlight kind of where each of these funds are as of our projections for the end of 2025. And maybe this will help future considerations that we're going to discuss in a later slide, whether a fund even has the healthy reserve balances to be able to support other funds. So the very first one is our general fund. It is our only unrestricted fund. This is where all of the State Bar general operations come from. If you take out the grant-related expenses, the general fund actually makes up about 65% of total bar-wide expenses. So it is the most significant outside of the grants fund, and those are just ins and outs. Outside of the grants fund, the general fund does make up most of the expenses at the State Bar. So how is this general fund funded? It's primarily funded by the annual mandatory fees that the licensees pay. There are certain other fees, such as late and non-compliance fees, reinstatement fees, and there are also some programs under the under the general fund that we charge fees for. I didn't list those all here, but for example, we have MCLE providers, fee arbitration, law corporations, and LLP renewals that we charge fees for. However, the mandatory licensing fees is what funds primarily the general fund, and that makes up about 90% of total revenue. So the other portion is really small. The general fund, just as of our latest projections, and these haven't been updated because we're still in the process of closing the 2025 books, but as of our latest projections, the general fund has about close to a $25 million reserve balance. So for now, the reserve is growing, but in my future slide, I'll cover kind of the caution that I want to call out to the general fund reserves. I'm going to now move on to the restricted funds. The first one I have listed here is the admissions fund. This is the fund that has all of the programs. There's 12 in total, the main one, of course, being the bar exam. And this is the fund that is related to the practice of law in California. So all of the 11 programs in the admissions fund charge different types of fees. This past November, if you recall, we did advance all of the fee increases for the admissions programs. So for example, moral character, law school regulation, legal specialization are some of the programs. Not all of them, but just some of the programs. The bar exam, of course, that charges fees to fund that fund the admissions fund. And the admissions fund, as we know, has had a lot of issues. We had a lot of issues in 2025, but our projection is that it will end with reserves of about $3.4 million in 2025, which it is sufficient to get it through 2026, as far as I know today. The next one, the Client Security Fund. This is the fund that a licensee's clients gets reimbursed from, and it's up to $100,000. And this is anytime a licensee's client suffers monetary losses due to dishonest conduct on the part of the attorney. So then the Client Security Fund will pay the client or the victim, if you will. And this is actually funded by a mandatory $40 fee for active licensees and $10 for inactive licensees. The next one, the Lawyer Assistance Program. This fund provides education and rehabilitative services. to those that need assistance due to a disability related to either substance abuse or mental illness. And this one's also funded by a mandatory annual fee of $10 for active licensees and $5 for inactive licensees. The Legislative Activity Fund, I didn't go through the reserves. The reserves for the Lawyers Assistance Program, it's very, very small, so this one really couldn't be a fund that we lend to other funds. It only is projected to have 90,000, so it's almost breaks even on a year-to-year basis. The Legislative Activities Fund, this is meant to support lobbying activities primarily, and it is funded by voluntary donations of $5 if a licensee chooses to do so. This was converted to an opt-out fee, I think, about 2 years ago. So revenues in here have decreased significantly, and it really doesn't have many reserves left. There's only about $47,000 projected for this particular fund. Moving on to the Elimination of Bias Fund, this is to support certain programs within the Office of Access and Inclusion. It's also funded by a $2 opt-out fee, so it's voluntary if a licensee chooses to make that donation. It currently is projected to have only $177,000, so again, not a fund that necessarily has healthy reserves to be lending to other funds potentially. Now I want to move on to what I call the grant-related funds. So most of these are the revenue that comes in mostly gets passed through to subrecipients. I'll start with the grant fund. This one has various grants underneath it, and it's primarily funded by money that we get from the Judicial Council. And it's for various special projects. So right now we have Care Court 1 and 2 under this grant, small distributions from Homeless Prevention 4 grant, and then there's the Cal HFA 2 under the grants fund. And this almost breaks even, but again, it's funding that goes in and out. The Equal Access Fund is another pass-through grant. It is pretty much funded with Judicial Council grants that we get. This fund is meant to provide legal services in civil matters to needy California, and the grants are sent to approximately 100 nonprofit legal aid organizations. This fund has relatively okay reserves. It's about $2 million as of the end of 2025. The next fund is the Greg Knoll Justice Gap Fund. This is donations that are used to help close the justice gap. And again, this is funded entirely by donations from licensees. This one has, where am I? About a $5 million reserve as of the end of 2025. So, it's still in decent reserves. The next one, the Legal Services Trust Fund. This is the fund that's meant to expand and improve the quality of the existing free legal services to, again, needy Californians. This is where, maybe you guys have heard the term IOLTA. So this is where the interest on client trust account is kept. So any attorney that has client trust accounts, they're supposed to forward to the State Bar the interest, and that's what we use to then redistribute as grants. It's also funded by a $45 voluntary fee. And this is the fund that has a lot of reserves. As of 2025, it's $242 million in reserves. The decisions in the Legal Services Trust Fund is made by the Legal Services Trust Fund Commission, so we in the State Bar don't necessarily have direction there. And they've made it a point to distribute a lot of grants last year and this year and going into future years because the reserves have really ballooned with the interest rates being really favorable the last couple of years. And then finally, the Bank Settlement Fund. This was from a settlement between the Department of Justice and the Bank of America, that was received around in March 2016. So we received about $45 million, or close to $45 million. And this is distributed to legal aid, also distributed to legal aid organizations, but this is to prevent the foreclosure, prevent foreclosure legal assistance and community redevelopment legal assistance. And this is almost completed. I think it'll be just out of all of distributing its fund this year. There's only about $24,000 left according to our projections. Now I want to move to kind of remind the Board of Trustees, and particularly our new Board of Trustees, just a breakdown of the fee increase that we received in 2025, a much-needed fee increase that we did receive. The total was $78 for active licensees, and this is the breakout of the different components of that fee increase we received. It was the second, I think, fee increase in 20 years. So it was sizable, but it had been about 20 years since we had a fee increase, if I recall correctly. And what I really wanted to highlight here is that biggest component, that $52 that was meant to fund our staff salary and benefits. It is due to sunset starting in 2028. So at that point, the general fund really, we hit that fiscal cliff by losing that $52. So I just wanted to remind the Board of Trustees to have that in mind, because losing this really would, it is going to cause a significant negative financial impact to the general fund. And it was meant to fund us at a 15% vacancy rate. The reality is that without the $52, that 15% vacancy rate, even today, is much higher. It would be much higher than the 15%. Personnel costs keep increasing. Our CalPERS and our healthcare have consistently increased year over year. So we really need that $52, if not more, but at least to be able to keep the $52 come 2028. So something for us to continue to keep in mind. Next. And I just wanted to present some very, very high level preliminary budget projections for 2026. We are in the process of doing the 2026 budget. The board will approve it at the February meeting, and the Finance Committee is meeting in early February to go through a more detailed preliminary, primarily the general fund and the admissions fund is what the Finance Committee is going to see. I just wanted to highlight where the general fund and the admissions fund is as of the projections we have. The general fund is continuing to deficit spend. Some of these numbers have actually changed as of today, since again we're still finalizing and fine tuning the budget. But usually the general fund right now we have projected to have just about a $1 million deficit spent. And the admissions fund is actually a little bit lower. It's projected to have a $1.5 million deficit spending. The admissions fund, we were able to fine tune the actual applicants for the February bar exam. So that helped revenue in the admissions fund. So it's, as of today, it's actually 1.4 million deficit. And these are the reserves that we have projected as of 2025 for both the general fund and the admissions fund. They're both obviously sufficient to cover 2026 deficit spending. And I also put in here our 26 reserves, which for both funds, of course, they're sufficient to get through. But in the general fund, remembering that we're losing the $52, those reserves would very, very quickly get depleted. Next. Yes.
Based on what you just said, if I look at this chart, if the admissions fund is at a $1.4 million deficit now, that means that the reserves bump up by $1 million, so it's a $4.4 million reserve.
No, so because it's deficit spending, the reserves would be about 1.9 million. So they would be higher. The reserves would be higher because we're spending, our deficit spending is smaller.
Yeah, I'm sorry. I was looking at 2025. You're right.
Oh, yes.
Okay.
Sorry, yes.
Yeah.
That's correct, Arnie. And now I want to move on to collections. Aside from all of the different revenues that, or how the several funds are funded, we do have another mechanism to get revenues, and this is what I call collections. This is basically the 4 debt categories that we get funds from, and this is all related to disbarred and resigned attorneys. So when they have a debt that they essentially owe the state bar, and it usually falls into one of these categories that I kind of want to cover. And I do want to note that we do have a statutory authority to collect on each of these 4 different debt types, if you will. So the first one, as I mentioned earlier, is the client security fund. Again, when a payout is made to a victim of a maximum of $100,000, in turn, that attorney must reimburse the state bar for that money that we paid, plus processing costs and interest. Right now, the interest as of 2026 is 1%, and it accrues annually as long as that debt is outstanding. And then the next one is discipline costs. So when an attorney is subject to discipline, that attorney must pay for the cost of the disciplinary proceedings to the state bar. The next section, or the next type, if you will, is sanctions. These are penalties that are payable to the state bar that may be assessed against an attorney as part of a Supreme Court or state bar court discipline order. Most of our collections come from CSF and discipline costs. Sanctions is fairly new, I believe around 2022 is when it came about, but most of our collections come from CSF and discipline costs. And then finally, judgments. Judgments is monetary judgments that we enter in Superior Court, and that places liens on a debtor's property. So if they happen to sell a property and we have a lien on it, we can get a portion of those funds. And judgments can be entered at any of the three categories above, so CSF, discipline costs, or sanctions. How do we collect from disbarred and resigned attorneys? Well, we use the Franchise Tax Board. And I just want to note, on average, for disbarred and resigned attorneys, we've on average collected $1 to $2 million annually, and that's really only about 1% of the total outstanding debt we have. So it's not a lot, but it's something. And we do use the Franchise Tax Board, the FTB, to collect, and it is primarily through two programs. One is a court-ordered debt, and the other one is a tax intercept program. We periodically send the Franchise Tax Board debt files that has all of the attorney's information, and that's how the Franchise Tax Board is able to collect money. So it's either done via wage garnishments or bank levies. Sometimes for any debtor that we do send debt files to the Franchise Tax Board, we send 3 notification letters alerting the disbarred or resigned attorney that they're going to go into essentially collections with FTB. So sometimes they will reach out on their own to the FTB to get on a voluntary payment plan. So we get payments via that way as well. Otherwise, there could also be interceptions of tax refunds if there's lottery winnings or unclaimed property to satisfy unpaid debt. The tax intercept program was actually suspended during COVID, and it only recently started. So and we have to apply for it essentially every year. The most recent year was 2025. And we really didn't collect too much from that. It was only about $20,000 in 2025 from tax intercept. But I don't have any older data than that to see if this program had been more successful in prior years. And finally, I want to just highlight really quickly the Fresh Start Settlement Program that we had in 2025 and just ended. So just as a reminder, particularly for our new board members that may not have been here, this Fresh Start Settlement Program was approved by the board in September of 2024. It was also authorized by Rule 3.1000, and included in our 2025 fee bill, so AB 3279. Only in 2025 were we allowed to move 50% of the funds collected in the Fresh Start Settlement programs into the general fund. So normally it goes mostly really into CSF, and a smaller portion goes into the general fund. But for any settlements that were part of the Fresh Start Settlement program, 50% we were able to put into the general fund and the other 50% to CSF. This is really meant to help augment the general fund reserves. That was, the main point, that the state bar worked with the legislature to make sure that we could do that and help support the general fund. So that was only in 2025. Now it reverted back to how it always is, where if it's CSF, it goes to CSF. It was a 1 year, it was basically, just to summarize it, it was a 1 year offer and compromise initiative that we took on, and it was meant to increase our debt efforts. As I mentioned, we only collect about 1%, so 1 to 2 million. So we wanted to try to increase our collection efforts through this program and try to get a lot of the debt off the books, if you will. It did allow current and former licensees to settle their outstanding debt for a lot less than what they were owed. Or for a lot less than what they owed, excuse me. It was mostly for disbarred and resigned and suspended attorneys. They received a greater discount since they really have the largest debt. Active attorneys were also part of those who were eligible to participate, but they did receive a smaller discount to settle. We conducted this program via an online platform that basically allowed the participants to view their settlement offer. They were able to provide a counter offer if they couldn't afford that initial settlement, and then offer a proof of financial hardship if we were settling for significant discount, we wanted to show proof that they did have financial hardship. And then they signed, it was electronically signed, the settlement, so it was all of that was conducted in this platform. And it did end, as I mentioned, it did end 12/31/2025 was the end of that program. The total revenue that was collected was just under 3 million. It was 2.8 million. So in 1 year, it's better than what we normally collected. It did not meet our goal. I think our goal was 8 million in total. So it wasn't as successful in terms of collecting the 8 million, but in terms of getting more money into the general fund, yes, I think we did achieve that. I will present more of the program details. I just didn't have it by this meeting at the February meeting, kind of, who participated, how many settlements there were, et cetera. This is, in the future, we could consider doing the program again, but there's a lot of things we need to do to reinitiate it should the board want to attempt to do a program again. Certainly the bill, like I mentioned, no longer allows us to do 50-50 anymore, but it is, there are some caveats to doing this again. We do have to pay for the platform. It wasn't, we do have to pay for the platform. We didn't have as much, I don't have the numbers yet, but I'll share more in February. Most of the participants didn't even open up their accounts that we set up with them. So we didn't have as much participation as we would have hoped. So there is the caveat of how much outreach could we do again if we tried to do this program again is one of the key considerations. But nonetheless, it is a consideration that the board could choose to do in future years. And I think that's all I have on that portion. Go back to Laura.
Thank you, Araceli. Before I move on, did anybody have questions for Araceli about the budget slides? Trustee Sewell.
Araceli, thank you for this, and I know that our budget has been I'll just say a topic of concern for quite some time, and I just sort of appreciate you walking us through everything. A couple of questions for you. I did note in your comments, Araceli, some ongoing concern about where we are, and I want to appreciate that. My question, here are my couple questions. One is, it sounds like we're in a better revenue position in the general fund as of right now, and why is that?
Sure. So in the past couple of years, those late and non-compliance fees have really kind of sort of been a savings grace for the general fund. We've well exceeded our budget that we had anticipated to get in late and non-compliance fees. In 2025, I think, this is the November numbers, I don't have December numbers yet, but we collected, I think at that point, 3.6 million in late fees and non-compliance fees. So that has really helped obviously increase the revenues in the general fund. I think we had budgeted maybe 2 million at most, and it's been doubled the past couple of years. So that really has helped the general fund revenues. This year in 2025, our licensee fee projections also exceeded our budget, I think close to $2 million. That, I don't anticipate this going forward because the attorney growth is very, very small. It's, I think in 2025, we said it was 0.17% growth. But, our attorneys' licensing fees also exceeded our budget. Investment income has played a role too. The rates have been pretty good. They were in 2024, I want to say they were between 4.5% to almost 5% for our investments. 2025, they came down a little bit, but I was still able to get interest rates in the 4%. That is going to start coming down. Starting in the most recent investments purchases, it's now back to low 3, maximum 3.5%. So that's not going to continue the source of income that we had seen the past couple of years since the interest rates are coming down. But it's really, I would say, those three components that have really helped the general fund last year, meaning 2024 and 2025.
Okay. My next question is, how do we do on the golden handshake?
So there was two components of our voluntary reduction in force that we did in 2025. One was the severance. One was what we called the reduction in force, the severance agreements that it was voluntary. Whoever wanted to apply was able to do so. that was one portion. The second portion of that whole program was a golden handshake. That piece was the two, if they retired last year, they got CalPERS offered a 2 additional service year credit. So are you talking about?
Yeah, if you would just.
Or all of it?
Yeah.
I don't have the numbers. What I can tell you is we had targeted, or we had budgeted that 50 people in the general fund would take the RIF. We did fall short of those numbers. Only 39, if I recall correctly, only 39 out of the 50 actually took the RIF in the general fund. And some of those positions were critical, so we had to backfill them. So in terms of the money savings in 50 employees leaving the general fund, we did not meet that, which is part of the reason why you will see the 26 budget personnel costs not be what we had projected for 2026 and going forward. That accounts for a significant amount of money that we're not saving because essentially 11 people did not leave that we had budgeted. But that's all said and done. The golden handshake, so that all has to do with actuary and actuary valuations. That, however, won't kick in until the second half of 2027 because we do incur by doing an additional 2 service year credit in CalPERS. The State Bar does have now your post-employment responsibilities to anybody who retired. Those are going to kick in the later half of 2027 for the next 5 years, and that per year, if I recall, is about 1.8 million that's going to start hitting the general fund, or any fund really that had employees retire. It's going to start hitting at about $1.8 million starting the later half of 2027. But again, those are actuarial assumptions. They're going to have to redo the assumptions this 2026 to see how much of that, if that 1.8 million is still holds, but that is what we will put in the budget because that is the best estimate that I have to date.
Thank you for that. I do have one more question, and that is, this may be more of a Laura and a Erica question. During the course of some of my discussions with the State Bar staff around some of the immigration work, I learned a new term, and that term was cypre. And I wonder if you could just sort of remind me of what that is and where that fits into this, if it does fit into this, because from what I'm recollecting, it might be something that we might need to execute some additional sort of legislative authority around.
Sure. So I may have Aline jump in to save me at some point here. But so cypre allows for it's where oftentimes there are class actions and other large settlements from which there is a balance that remains. So it's not delivered to the those who should be compensated. Most recently, this came up, I believe, Araceli, last year, where we got a $3.8 million award, I want to say, that was a cypre award. It basically transfers to the State Bar to fund legal services, and there's a lot more discretion in what we can use that amount of funds for that is different from the restricted funds that can be used for very specific items within other grants that we receive. So these are good things to have. This already exists by statute. I believe it's within the Code of Civil Procedure, but there is a movement within the legal aid community to further promote this option as something that exists by perhaps developing a rule of court to remind judges that this is something that should be pursued so that this money can essentially a sheet to the State Bar to be utilized to fund legal services. So I don't know that there's a statutory change that's necessary here. It exists within the law already, but certainly promoting awareness of this fact is something that would benefit the legal aid community ultimately, including to fund other types of legal services that we're currently more constrained to do within our grant funds.
Araceli, in terms of each of the restricted funds, is there a general and administration sort of indirect cost that we absorb to cover our expenses in terms of cost of doing business? So for example, if there's a fund that's restricted and it's $50,000, is there a percent of that covers our intern, like how do you determine, is it a percentage?
Mm-hmm. So it's by it's by office, but certain offices, so for example, State Bar Court, the State Bar Court pays into the funding of what I'm calling the indirect costs. So the indirect costs are really more for the administrative offices, HR, IT, finance. So it's not necessarily by fund, but each of the offices that do get indirect costs, there's a different methodology. Some of them are based on headcount, some of them are based on square footage, depending on what the office is. So general services might be square footage. I think admissions, I want to say, is by FTE. But yes, there is a portion that, not necessarily by fund, but it's more by office, depending if there's more direct costs associated with them versus indirect costs, which again tend to be the administrative offices. There is a methodology allocated to fund us, essentially, fund the administrative offices.
Yeah, but if that methodology was more even across the board and not by office determined by FTE, but wouldn't that in some ways help us in this sort of position to a certain very small degree?
In the general fund? In the general fund?
In any of the funds, right? Like if you're not covering the cost of doing business, I guess is what I'm trying to get at. I would assume you could increase the indirect percent so that you do cover the cost of doing business. And the cost of doing business is beyond perhaps that FTE count. It actually hits a lot more, staff that maybe are not, I think there's like a broader story to tell there perhaps, but that's what I'm trying to figure out.
I do know our methodology has been reviewed by the state R, and we have hired consultants in the past to make sure that our methodology is sound. I guess I don't know what, if I were to redo the indirect costs, yes, certain offices would, so admissions I could tell you would probably benefit, but then the general fund, which gets reimbursed, might suffer if admissions pays into the indirect cost pool, and then the general fund, for example, benefits from that reimbursement. So it could be a pro or con depending on how we would change it for each office.
Yeah.
Does that?
Yeah, and do you revisit increasing that cost year over year, just sort of as almost as a cost of doing business percent that you would add on top of the current indirect?
Not the percent, but we do always calculate what is our cost pool and then allocate that by office. So, what is our total cost pool of all of the direct offices that we've incurred state bar-wide, all of the direct offices, and then the indirect offices, the offices that have indirect costs, that's where, if we say there's, and I don't remember the numbers from the top of my head, but I think right now the general fund gets reimbursed, I think 13 million from the direct offices. And that's purely based on, again, the general fund, that's purely based on the offices underneath it, that sometimes it's allocated based on FTE, sometimes it's allocated based on square footage as the most common ones.
Yeah. I think it'd be interesting to increase that year over year because your expenses increase year over year. So if you have a stagnant indirect percent or, however the methodology is, that I think it's reasonable to increase that year over year, because it would help support more of the expense, I guess, is what I'm trying to get at. Does that make sense? Or maybe not, from your perspective.
I'm not sure I follow, just because our cost pool is based on what is in the budget for expenses. So it's not like we can say, it's whatever, $50 million, let's add 5% to it doesn't work that way. We get the actual expenses that we incur, and then all of the offices that get reimbursed, it's determined not as a percentage, but on the methodology of the indirect cost. So it's, like I said, it's usually square footage. The most common ones that we have is square footage or FTEs. That's how that pool gets allocated or reimbursed to the general fund, for example.
Okay. I think I'm following, but I can always.
I can share our methodology. I think it would help for you to see it. I think it would help if I could walk you through it.
Great. And then just one more question: is there a world where we would pursue less of a fee increase in exchange for the ability to move resources from across funds? So I guess what I'm trying to, and I'm trying to figure out, you would want to pursue a fee increase because it's needed, it's necessary to cover the cost, but at the same time, could you pursue less of a fee increase, but in exchange, be able to move resources around, and maybe there's a threshold on which funds and to what extent, and, you know, funds that have $242 million in reserves, perhaps, you know, those are the funds we could perhaps move around to cover expenses. There's a case to be made there, I think, but I'm just curious.
I can, so we actually have a slide on cross-funding on some of these situations.
Sorry.
But to your answer is, I think that's a policy question of something, one, if the funding were available, and two, if we would be able to do that. You know, I have seen coming from other government agencies where we work with Department of Finance, they say, okay, you're going to use this to cover for the next 2 years, and then we'll fund a general fund later, or something like that. It could be a conversation like that as far as the fee bill. But again, it would depend on the health of each fund and the purpose that the fund is for. Because, for example, the Equal Access Fund is pretty restricted in only going towards particular access programs. And I'm not sure that it's a policy question, really.
Sure. Okay, thank you. I appreciate it.
Okay, with that, we have 2 more hands.
Yes, I think I'm next. Is it all right to go?
Yeah, go ahead.
So I know we've had past discussion about the admissions fund. There's concern about the admissions fund. And I know that recently you just mentioned that there's slides on cross-fund transfer of funds and the restrictions and issues associated with that. But a thought did come to my mind, and I don't know if this has been explored already or not, but candidates for admission who indicate that they are going to go into the legal services industry and work for a legal aid organization, I'm wondering if that could create sufficient justification, and if tracked, to support the transfer of money from funds like the Justice Gap Fund or the Legal Services Trust Fund, or maybe the Bank Settlement Fund, because they are going to help through their work, if admitted, close that justice gap and provide legal services in that industry. And I know that there might be a procedure that needs to be followed to authorize that transfer, but it was just a thought that came to mind because I do think that there's a nexus there.
Again, I think that's, again, a policy question similar to Trustee Barjona's, is we can look into options related to cross-funding, and that is one way you could potentially tie it to those access to justice programs, yes. Has it been explored in the past? I don't believe so.
If I may just add, I do believe that if an attorney works for a legal aid organization, they can get a fee scale.
Yes.
So once they become attorneys, they pay a lower licensing fee.
That is accurate.
But when they're attorneys, yeah.
But my I guess question or suggestion was a little different. It was more about justifying maybe a portion of funds for transfer into the admissions fund based on the stated intent. Maybe there needs to be some type of offer letter, I don't know, submitted by the candidate. I don't know how it's tracked, but maybe that could justify money being transferred from those funds designed to address those legal justice gap, legal services issues, transfer of money into the admissions fund to maybe cover some of the costs for helping them get admitted into the practice of law in California.
I think that would require statutory change as well, if that's, I guess we could look into that further, but to even make that nexus and connection, given the statutory language with respect to the justice gap funding, I think we would need the legislature to authorize that.
Trustee Good.
I'm sorry, one more comment, that people that donate into that fund, they donate it for a specific, purpose, that it's going to go to legal aid. So they would need to understand that additional sort of, potential use of the funds that may impact the ability to actually collect. That's something that I think we could explore in terms of understanding, but just wanted to point out those two considerations.
Yes, thank you. It was really more of a comment for Araceli. I noted that our budgetary assumptions for fundraising for both the Golden Handshake and the sort of collection program that we instituted were off. And I just wanted to sort of caution us to, I know forecasting is inherently difficult, particularly for brand new programs. So I know that's tough to land the airplane, on the runway, so to speak. But I do think maybe we should think about being a little more conservative in some of those forecasts down the road, because certainly on the basis of those forecasts, we approve costs to set up that other program that I understand we're going to talk about more in February and whatnot. And, funding is of critical importance for the bar. So that was really my only comment was let's try to be a little more conservative on the front end to the extent that we have additional opportunities to recapture future funds. Thanks.
Thank you, Sarah.
Go ahead, Trustee.
Thank you. I would like to know a little bit more about the admin fees, or I don't know if, I look at it as a fiscal sponsor fee for the grants funds. Because we don't make the decisions on who gets the money, right? I mean, they're restricted, but there is staff time in managing it. Certainly, there's a lot of fiscal management that your office does, and there may be others. But I'll give you an example. A lot of nonprofit organizations, when they don't have their 501c3 status, they go to like the Tides Foundation. I'm just giving a foundation, and the foundation will charge them a 15% fiscal sponsor fee for what their revenue is. That'd be an example, okay? How does the state bar do that in terms of making sure that it's kind of a little bit like Trustee Barahona's question, just another angle of it. How do we make sure that our expenses are covered, that we're not going into a hole because we're administering somebody else's money?
Mm-hmm. So most of our grants fund do have an administrative cost reimbursement component to it. Mm-hmm. So we do get reimbursed for the staff that manages these programs. Usually the amount is either set at a particular dollar amount or a percent. I think 10% is what I've typically seen. So you can only get reimbursed up to 10% of, I think it's of the total grant, or it's either stipulated the actual amount. Sometimes it does our staff time, and this includes obviously not just the Office of Access and Inclusion, but for example, finance, because we process all of the invoices and payments. So there is finance staff time that we do, that we are able to bill back for each of those grants. It's not always enough to cover it, but this is where the funds in the Legal Services Trust Fund kicks in to make up whatever, let's say EAF didn't cover. But we do have administrative cost reimbursements in, I believe, most of our grants that we do.
Okay. Maybe at the next meeting we can, maybe have a little sheet on that. A little bit more information.
Okay.
So,
Trustee Tony, if I may,
I'm sorry, please,
just to add a little bit more.
Yes,
so it depends on the grant agreement. It's typically, I think it's 8% for many of them.
Okay.
There are some where we hit the 8% and then continue, but that then comes out of the IOLTA funds.
Okay.
So which there is just more discretion with it. So
Sure.
that's that interest off client trust accounts, as Araceli has mentioned previously. There are also, just to kind of put a finer point in this, there are many offices that support the Office of Access and Inclusion. So finance, OGC does as well, our Office of Research and Statistics, among others. So there is a allocation from IOLTA funds and in some instances other grant funds that is proportioned to those offices that provide support. So none of the funds that fund, so none of the work that's done for the Office of Access and Inclusion comes out of general fund.
Okay, that's useful.
And we can provide certainly more detail about that.
Thank you. Now, on the question of collections, when I'm looking at the slide for collections, you know, I think we all agree that 1% is a pretty low collection rate for debt. And one thing I wanted to know is, I don't see it on here. Do we have probate on here? You know, probate's about the last chance you have to collect a debt from someone. Okay, and you know, it just seems to me that if somebody owes the state bar debt, you know, all the probate notices say if you have a claim, you got to submit it within a certain amount of time, you know, for the judge to take a look at it. And do we do that, or can we?
Maybe.
Yes, it's my understanding from my staff that manages, and supports finance, that we do look at the probate.
Oh, good.
And when individuals are deceased. And we also file judgment, so sometimes it may come up through that process as well.
Oh, good. I didn't see it listed. That's why I asked on the list here. And on the in the discussion on Fresh Start, there was a explanation that disbarred and retired attorneys were given a better offers, makes sense, than active attorneys who have debt. And I'm wondering, if you're an active attorney and you have debt, it seems like there's more leverage there. Like if you don't have an arrangement, you can't practice something. I'm just wondering, how come we can't collect from active attorneys? Yeah.
Do you want me to? Okay.
Because I don't know.
So there are some very few attorneys who are active and may have some debt. In most instances, attorneys who are suspended have, so not disbarred and not resigned with charges pending, have what's called an and until, as we call it, which means that they cannot be reinstated as active until they have done many things, including paying their discipline debt to the extent they have client security fund debt, as well as doing anything else that the Supreme Court ultimately orders them to do, such as within probation and those types of things. So that's there's not a lot there. There are some who are reinstated and active that are on payment plans and those types of things, but a condition of remaining active is to follow those, and if they're not, it's considered a probation violation, and then they're disciplined again.
Okay, thank you, appreciate it.
Thank you. All good questions. So we're going to go to the next slide now and talk about the future funding opportunities. So, okay, we're good. One thing that has come up, at least in the last several meetings, and I think probably prior to my time with the bar as well, is looking at grants, which we do already receive, gifts, and public-private partnerships. So we're going to talk about those a little bit now as possible opportunities in the future. So currently, the state bar has had a few examples of past contributions. So we've received grants for legal aid outcomes, data related to domestic violence legal assistant, for a project for modest means and affordable legal services, and grants to explore bar exam alternatives, such as open book, remote testing, and extended time. Most of the grants we'll see are, again, related to, they're going to be program related, or they're going to be related closely to access in some way. For example, the grants for the bar exam alternatives is looking at greater access to that exam, and therefore greater access and inclusion within the profession. I'm using the wrong clicker, sorry. So again, I mentioned the programmatic and theme of grants we often get will be access to justice or those in diversity, equity, and inclusion programs. So they could relate to legal aid, immigration services, addressing legal deserts, pro bono coordination, attorney recruitment, retention, and succession planning. And that really is for those kind of legal deserts where if the one or two attorneys in that area decide to retire, they become a full legal desert without access. So that's what succession planning means in that instance. We have, which we've talked about quite a bit today, the Legal Services Trust Fund program. That's our grant making arm, and that's where we often, as mentioned by RSLE, we have like the Equal Access Fund, which is really a pass-through grant from the state general fund, goes to the Judicial Council and then to us here. So really, any strings attached to that grant are often found in the budget bill language, the state budget bill language. But in the, so the Legal Services Trust Fund Commission administers the revenue from the following sources for those grants for civil legal services programs for low-income California. So we have the IOLTA accounts that we've mentioned, the Equal Access Fund, the Justice Gap Fund, and there may be other ad hoc grants. We've recently had some with some housing agencies related to foreclosure prevention and stuff of that nature. There are some limitations on what the State Bar can and cannot accept as far as gifts. So the State Bar can accept gifts and monetary donations, but again, this is something we really need to be careful about and consider the conditions of it as well as the source that it's coming from. Does it pose a conflict of interest? Are the conditions too restrictive, or maybe even they could be overly broad in a way that doesn't work for us? There's no statutory prohibition on who can donate, but we want to, again, avoid conflicts of interest, reputational risks, depending on who we are taking funding from. So having a clear policy is going to be really important if that's something we want to further look at there. We cannot, though, create a nonprofit foundation. So a handful of other government agencies are able to create, have an arm that is a nonprofit. Statutorily, we are prohibited from doing so. So without statutory change. So if that's something to explore, then that needs to be a policy legislative discussion. Currently, we cannot do that. So for-profit subentities or joint ventures, those will be permissible provided they serve a public purpose and avoid gift of public funds when it comes to our portion of funding them. So we would, again, need to work very, very closely with OGC to make sure if we were doing anything of that nature, we're structuring it in an appropriate way that that meets the legal requirements, that protects the State Bar. We really are acting as fiduciary of State Bar funding, and so we want to make sure we are protecting that. The State Bar can share or delegate some decision-making authority to the partners in such arrangements, but they most likely must retain the ultimate decision-making authority, especially with use of our actual State Bar funds. And then finally, on tax considerations, donors can claim tax deductions, whether they give directly to the State Bar or to a foundation if we were to get authorization to do so. This is true as long as the funds are used as a public purpose and the uses are consistent with State Bar mission, which basically will make it public purpose as long as they're meeting that threshold. But, we have seen already many different actions on the federal level. So the current administration could challenge uses related to immigration services or DEI as not public uses. We don't know how successful that would be. We don't know if they would do such a thing. But we have seen things at that level out from the administration already that would call that into question. I don't know if that denies tax deductibility, but it would be an open question for those who may be interested in working with us or gifting with us. Gifts are tax neutral because we're a government entity, but for any for-profit venture would trigger income and sales tax obligations. So we want to be aware of those limitations if this is a topic we continue to explore. And then finally, our last slide here is that cross-fund considerations. So there's no statutory prohibition, although on using license or general fund basically to subsidize the admission or bar exam costs, though often when we're talking cross-funding, it will at least require notice to the legislature, if not their approval. Given history, we would probably want to proactively seek them out and have that conversation before and vet that through if that was something to be looked at. Admissions fees are subject to Proposition 13, so that limits them to the actual regulatory costs. Increase must reflect a reasonable relationship to benefit or burden and cannot create a surplus. So when you see those, we come in with changes to admissions fees, it's very closely tied to the amount needed to run those programs. And we can't go over that. We couldn't raise the fee just to generate revenue because that's a protection that Prop 13 provides. And then late fees, we must show a nexus between the fee and the benefit or burden. So again, it might be difficult to justify our admissions bar exam subsidy. And again, Trustee Barahona asked earlier about like that cross-funding and if we would be willing to negotiate a change or work on, we can cut the amount of our fee increase this year if we can use funds from this fund. And that's really one, looking at the funds internally for us to know what they're funding now, what they could be funding, and two, working with the legislature on that and if we want to do that. So that's how that would work. So really any cross-funding outside of like admin fees on grants and things that are not really cross-funding, they're just paying the admin fees even if they're in different areas of the bar, we would definitely have to be having with the legislature. So that's and I thought it was really important to kind of talk about the budget as we're going to move into the next item of the strategic plan and what will be coming over the next year so that everybody had a full understanding of where we are, things that may impact that budget, things that may require legislation and that type of thing. So with that, I open it to questions.
Any questions? Trustee Grande, go ahead.
Thank you. Thank you for the presentation. I don't know if it's a question, or yeah, maybe it is a question. For our next meeting, could we get just clear numbers on how much we get from the different programs, the MCLE providers, the law corporations, things like that? Because I see that there's an opportunity. We have so many solo attorneys that are sole proprietorships that I don't know if we've done like a campaign that demonstrates the value of owning a professional corporation, where I think that could bring in some revenue, and then that's ongoing revenue that we could, carry over year after year. So I don't know if we've ever done things like that, but I think given our MCLE providers, I know some bar associations are MCLE providers, others don't know. So also just doing campaigns to raise awareness so that, because those are annual fees that will keep on coming in. So those numbers would be great to know.
Yes, and also just as a reminder, this year every 3 years we look at all of the fees that we charge, all of the programs in both admissions and the general fund. We got ahead with admissions, but later on this summer we're going to take another look at all of the programs in the general fund and potentially seek fee increases there. But we do have revenue numbers by program type that I can share.
Anyone else? Trustee Sewell.
So next month, Araceli, the Finance Committee will meet to basically put together the budget.
Yes,
And-
correct.
And that will come to the board at the February meeting as well?
Yes,
correct?
the board has to approve the budget at the February meeting because it's due to the legislature on the 28th. So the Finance Committee is going to get really a preview of it first and make any recommendations or decisions if different than what we're going to present. But then the board sees the final budget and will hopefully adopt it, or really needs to adopt it at the February meeting.
Any other questions? All right, we've been going for quite a stretch. Why don't we take a 10-minute break, and then we'll come back with our agenda. And I don't think lunch is here yet. Go
May I
ahead.
make a suggestion?
Yeah.
Because we're ahead, can we just lengthen the lunch? Like, take lunch now and come back at 12:50?
We can do that.
We'll still be ahead.
Yes, but lunch has not yet arrived.
Yeah.
So we're taking a short break right now. Or do you want to take
I was suggesting taking a longer break since we're ahead and we didn't take a break earlier. So we would have a 50-minute break now.
Lunch is supposed to arrive around 12:30, so we can break still until 1. People can take a break, do whatever they need to do, as well as grab lunch once it arrives. And then we may, maybe a little bit of a working lunch when we come back in at 1, but that's okay.
Sounds good. Let's do that. Everybody, back at 1. Thanks.
Thank you.
Hello, everyone. Coming back from our break, continuing with the State Bar Board of Trustees meeting. We'll continue with item 5.3, 2022 to 2027 strategic plan. This item is being presented by our Executive Director. Laura, take it away.
Good afternoon. So this is our last business, second to last business item of today. So this is the strategic planning review and update. Today's session is focused on strategic planning for 2026. So what we'll start with is a review of the 2022 through 2027 plan, what has happened thus far, what is set to be happening in 2026, and a few of those initiatives in out years past that. We'll go over the input received from the trustee survey and talk about the discussion will be the board discussing how we want to move forward with the strategic plan. One thing to keep in mind is that we will be doing a 2027 to 2032 strategic plan coming up in early 2027. So the 2022 to 27 plans was adopted by the board in March of 2022, and it started centered on 4 goals. Those 4 goals remain the same, and we'll go over those on the next slide. It expanded to 5 goals in March of 24, and that was that 5th goal related to technology and data management. It's reviewed and updated annually by the Board of Trustees to assess progress and determine if any modifications are necessary. So just a refresher, the 5 goals are protecting the public by strengthening the attorney discipline system, protecting the public by enhancing access to and inclusion in the legal system, protect the public by regulating the legal profession, protect the public by engaging partners, and protect the public through innovative use of technology and responsible data management. And there's a full report with this agenda item on the materials. So this highlights some of the key things from our strategic operational plan, which is our document internally, our plan internally that we use to accomplish the 5 overall goals. So we started when the plan was developed in 2022, and since then, we had 208 activities within the strategic operational plan to accomplish. So we're working towards that. So remember, we started with 208. And then we stand today, of the 208, 95% of the activities are complete or in progress. 69% are completed, 26 are in progress, and only 5% have not started. So this is a really strong progress towards completing all of those activities as we move forward. So as we move forward, there's the 65 that are either in progress or scheduled to be started. And these are broken down by office. I'm not going to go over each one individually, but you'll see that all areas of the State Bar play some role in moving forward our strategic plan. So some of the key things, talking about what has been accomplished, and these are just some highlights. Again, the full report is online. So for goal 1, again, is strengthening the discipline system, and we've made major strides here with work in OCTC reorganization for more efficiency, new case processing standards, attorney-client bridge program, the recently implemented generative AI framework for, again, improved complaint review efficiency. You'll see a lot of these activities and relate to reducing the backlog, which was a big highlight on the Board of Trustee member survey that we will go over as well. So coming up in 2026, we will move towards expanding AI use now that we have the program and began implementation in complaint review and intake, rotate staff to manage complaint volume, and continue streamlining case handling. We also will continue to explore regulatory changes to incentivize compliance. Thus, again, all working towards that reduction in backlog and case processing times. For goal 2, this focuses on access and inclusion. Highlights include the DEI Leadership SEAL program, implicit bias training for bar exam graders, the completion of the 2024 Justice Gap Study, several multilingual outreach campaigns that you heard about earlier from our team, tracking pro bono hours statewide. So again, these activities are contributing to inclusion, but also public protection through those outreach campaigns, allowing the public to better understand the role of the State Bar and how to contact us to seek assistance. And then in key activities for 2026 to 27 in goal 2, we continue include reviewing law school rules, launching a statewide legal tech initiative for legal aid, improving data reporting frameworks to reduce burdens on grantees while increasing transparency. Again, you'll see in the survey results, there were results that favored pro bono incentives and law school evaluation, connected also to the mandatory pro bono reporting that went into effect just this year, and accreditation reviews. So we are meeting and planning on some of the key initiatives already that were reflected in the trustee survey. Goal 3, key accomplishments, regulating the profession, again, implementing CTAP, which was a big accomplishment, and we have started the audits within the CTAP program, and compliance enforcement, again, strengthening trust and accountability. Key activities we have on deck for goal 3 include COPAC guidance on artificial intelligence, that's artificial intelligence use by attorneys. Work with the legislature on distribution of funds from deceased attorney accounts. Revising State Bar website resources to ensure clarity on attorney obligations. And again, analyzing CTAP data provided by licensees and outcomes of mandatory compliance review. and investigative audits to find trends, data points for use in policymaking, advocacy, and program design. Goal 4 is about partnership and engagement. You heard about many of these initiatives already from the presentation earlier. We've enhanced public meeting accessibility, formalized media policies, launched the redesigned public websites, all improving transparency, and again, educating the public on the role of the state bar and how they can seek assistance from us and find further information. Key activities coming up. Again, developing relationships with external philanthropic partners, CBOs, and other non-IOLTA funded organizations to explore opportunities for collaboration, expanded use, user ability to auto-translate the website content into multiple languages, expanding digital outreach campaigns beyond Spanish to other frequently spoken languages in immigrant communities, identifying and implementing a new training platform to improve accessibility and accountability for our new board members. So again, revising and improving the training when we get new board members that come on. Implementing the voluntary ADR certification program under Business and Professions Code 6173, and that is a legislative or statutory mandate. And then goal 5, was added in 2024, which is why you're only seeing the 2 years of accomplishments here. This again focuses on technology and data. We completed IT assessments. We worked towards strengthening cybersecurity, which is an ongoing program, and redesigned the My State Bar profile interface for a better user experience. And then coming up, we'll be looking into, again, content audits, better organizing site content, meeting search engine optimization strategies, and other goals. Again, these are all formulated toward providing a positive user web experience and driving search traffic to our offered programs and services. We'll strengthen support teams for critical applications and train additional resources on Odyssey to supplement and augment the current team. Continue to work on cybersecurity assessments, cost-benefit analysis of the Odyssey system, establishing a data governance framework with an end-to-end data lifecycle management, implementing a new matter management system. We'll be rolling that out as well later in the year, and updating IT policy documents and institutionalizing operational IT framework. Again, these are just a few select goals from each area. The full report is in the materials as well. So then we have the strategic planning session. Let me move my mic a little bit. So we have the strategic planning session survey results. If you recall, you saw a preview of these results in November. We were asked to send that out again. And we did in December, and we did, I believe, got 5 more responses, leading from 6 responses to 11 responses. So the next few slides summarize the initiatives the trustees highlighted for each goal and how they may relate to some of the accomplishments and plans that we have already discussed in my earlier portion. This slide just highlights the areas which we received comments in. So for example, discipline system capacity, we received 4 comments on the surveys. A big one was AI and technology. Next one, a bigger one was also partnerships. So these are responses. Goal 1 in the survey was just an open-ended question. So the first 4 you see there in the black ink is, they've already been in here. You would have seen them in November. The 2 at the bottom there are new. So the 2 added where we reevaluate case processing standards, adopt improved operational practices, including tech, to focus on highest risk cases and reducing backlog. Another one was hiring 25 or more OCTC attorneys via bonding to address complaint uptick and more timely resolve matters, mid-year check-in on discipline trends. Next, related to managing client expectations. Again, the two new ones added to by responses after November were the assisting the public in navigating the complaint process, improve understanding of resources beyond state bar jurisdiction. That is also part of that outreach campaign and education on what the state bar does, what is within our area of jurisdiction, what is not. Leveraging public member chair or board leadership to engage consumer-facing organizations and reinforce consumer focus, which again goes towards those activities we have been working on towards public protection. Offering law practice management. These are ones you have seen from November. Pay for an audit on their practice. So this is a proactive law practice management, could pay for an audit on their own practice and obtain recommendations for compliance. Create a law practice management division, which would be a fee-for-service division to help attorneys stay compliant. Monitoring review, mid-year check-in on demographic of disbarred attorneys. And I believe we are already in the plans of doing a mid-year update on the annual discipline report. The surveyed incentives, so these were ones that were pre-listed for item 2 that trustees were able to either say they favored or were neutral or had lower favor towards. So the first 2 actually tied at the highest favor or highest priority, so incentivizing pro bono legal services, evaluation of California accredited and unaccredited performance related to law schools there. The bottom 2 were actually ranked in lower priority significantly than the first 2. Support development with only a third of the trustees about support development of a community justice worker program, which on a side note, we put in, there's been a petition submitted to the Supreme Court on a rule for community justice workers. We are working with them and awaiting response from the court on anything there. Support immigration defense and related services. Additional initiatives added, just with this, again, open comment area, more focus on collaborative partnerships, use of tech to help individuals find attorneys, investigate and enforce rules to stop unlicensed referral services, increase level of attorney preparedness to reduce discipline or subpar practice concerns, publish an annual California Legal Access Gap Index to track unmet needs, and tech-enabled access such as remote legal clinics, multilingual chat, and AI-driven resource navigation. Goal 3. Oh, that goes quickly. So the surveyed initiatives, the highest priority one received was develop law firm succession planning requirements. Lower priority one with, again, only about the third of the trustees, develop other proactive regulation obligations beyond CTAP. And then again, here you would have seen the first 3 initiatives in the survey in November. And the last one there in blue, update CTAP strategy to evaluate and refine CTAP using 2025 audit data, assess if random selection of 100 is sufficient to deter misconduct. I do want to make a note on that is we did do the 100 in late 2025 on the audits. However, we're now in the period where they're just doing audits and they can do up to 800 a year. Not, Steve can correct me if I'm wrong, but not likely to do 800 this year, but we are ramping up towards that. Goal 4 is engaging our partnerships. Explore partnerships to reestablish state bar swearing-in ceremonies. And then additional, that was surveyed. Not much either way on that one, mostly neutral. Engage strategic, so another initiatives added by trustees, engage strategic communications to highlight state bar leadership and legal service partners through stories, showing competence, consistency, and transparency. assess current partnerships and explore opportunities to bring other partners and stakeholders on board. And then the blue one here, again, kind of conflicts with the surveyed initiative of questioning the value of reestablishing swearing-in ceremonies, reiteration to avoid more regulation. And then finally, goal 5. The last two there are new ones since November. So again, use AI to improve state bar related services with human oversight. Oversee state bar staff of use of AI in work activities. Again, we are working to implement that AI governance framework that was passed or approved by the board in November. So we are, I think bullets 1 and 2 are both underway. Have a reset year, then reevaluate. Stricter cost benefit review of technology versus in-person logistics for the bar exam to prevent unanticipated costs, to align tech investments with fiscal realities. And continue improving financial practices at the state bar, which again is something I think we're already working towards as well. And now with that, that's the end of my presentation. It's really open discussion time to if there are things you want to look at differently in 2026, add, change. If we leave it as is with the expectation that we're going to be doing the 2027 through 2032 plan, with the awareness that we do have these other 65 activities that we are working towards as well. So with that, I will turn it over to the Board of Trustees.
Thank you very much, Laura. I will open it up for discussion. Do I see any trustees who would like to comment?
While people are thinking, I will.
Okay, Trustee Tony.
Thank you. My first question is just a technical language question. The part that says hire 25 OCTC attorneys, there's a parenthesis that says via bonding. I don't know what that means.
So that's a comment that was received from one of the trustees. So that's verbatim pulled from the survey. I'm not sure. I'm assuming via bond funding was my assumption when reading it. But we would have to, I'm not sure which trustee submitted it.
If anybody knows what you meant, I'm just curious.
Looks like Trustee Good has.
Good.
Thank you.
Oh, it wasn't me. I had my hand raised for a comment. I actually had the same question. I didn't understand it either.
Okay.
Okay, well, I'll go to my next question. If someone, I just want to make sure in the goal 1, that we add, this is on the AI, that we make sure that we bring AI use proposals for board approval on there. I just think it's good to have that there. I know that that's what we decided in part of our policy. So, I do expect in 2026 we'll be expanding our use of AI. I really appreciate the guidelines that we all adopted. So, and that's part of the picture. I also realize that sometimes you have to do the pilots first, okay, to be able to refine the program and come. So I don't think you necessarily have to come to the board before every pilot, but I do think in terms of big implementation, that's my interpretation of what we adopted, not to get in your way, but to make sure that we're all aware. Thank you.
We'll make that note and make sure that the AI use is in compliance with the framework that was already adopted. As far as we're currently doing an inventory of all AI use, we have not yet found a high-risk AI use that would need board approval, so there aren't any in that category yet. That doesn't mean there won't be, but as of our inventory right now, we don't have any in that category. Twice a year, we'll be reporting that whole inventory, low, medium, high risk, to the audit committee as well. And then, of course, any high risk items would be brought to the board.
Trustee Good.
Yeah, I just had sort of an overall kind of comment, really. I know that there are a number of things that are very fundamental to the state bar's mission and frankly, what we're all about, which is administration of a full and fair bar examination that goes well and is fair to all applicants, and running, a really strong and effective, but also timely discipline system so that bad actors are prevented from continuing to do bad to the public by having complaints dealt with in a timely fashion. And I'm also aware that, of course, our mission includes important things like access to justice and accessibility of the profession, a lot of other things. But one of my sort of overall questions is, are we taking on too much and thus falling short on some of those critical things that we need to do? For example, the bar exam, the discipline system. So I just wanted to put that out there. We do a lot of great things. We have resources, but we have limited resources. And I want to make sure that we do the things that we really, really need to be doing extraordinarily well, which I don't think we did do last year. So I just wanted to throw that out there for conversation and discussion.
Thank you, Trustee. Any comments? Trustee Sowell.
I do have some other comments, but just to piggyback on what Trustee Good just said, I also am interested in sort of the current kind of fiscal environment as well as the overall staffing environment that we find ourselves in right now. To Trustee Good's point, do we actually have the capability to do everything it is that we have outlined in the strategic plan? And so, Laura, I sort of look to you a little bit on this in the sense that, you're new, you've come in, you have a little bit maybe more of an objective eye, as you've come in. And so just wondering what some of your thoughts are as it relates to, as you look at the totality of this strategic plan.
So it is a lot. There's definitely a lot on there, and all relate to very laudable goals, as Trustee Good said. Resources-wise, staffing-wise, right, we are already working with the 15% vacancy rate, with the potential that it might need to be a higher vacancy rate depending on how funding goes and how the fee bill goes. From my perspective, I think the focus should be on those core operations that we need to be doing: regulation, discipline, the admissions, the bar exam, those types of things. Get those done and get those running well and doing right. Then if we have capacity, and this again is coming from my perspective, if we have capacity, it's at that point that we would want to look to broader things. There are some things that could be reevaluated in those activities still set to go. They could be delayed. They could be removed from it. I mean, a lot of them do relate to improving public protection and attorney discipline. And by that, I mean, we're improving the attorney discipline system, but we're also doing other programs that hopefully keep people out of the discipline system as well. But, again, core focus, core operations, meeting the main mission, which is admissions, regulation, discipline, I think should be a priority for us. Because that's our regulatory role.
Does that mean you might have thoughts or ideas as to, what we should delay or what we should just sort of maybe toss overboard at this point in time?
We haven't done a full assessment of that. I kind of look at it as those necessary to run those core functions. There are often what we refer to as the keep the lights on initiatives. Like, these things have to happen in order for these things to continue. I don't, off the top of my head, say I want to pull one particular thing. We've delayed some things already that push them into 27 or 2028. So while the primary group of those will go in 2026, and in different quarters, not all starting right now. We continue, though, to evaluate as we move forward and if resources are available or not.
Trustee Good.
Just to follow up on Trustee Sowell's conversation with the executive director. So does that mean if we adopt the strategic plan, it doesn't mean that resources are going to be deployed across all of these things? Is that right? In other words, we're going to prioritize. I just want to understand like what that decision means in terms of resource allocation and prioritization. Yeah.
So we internally, the strategic operational plan is what we're working off of. That's where those individual goals are coming from. We can prioritize within that. They're also slated to go at different times within the year. Some are in quarter one, some are in quarter two, quarter three, quarter four, some are in 2027, and some are in 2028. We can continuously assess that. We're already working on assessing like the IT projects list. We know the big focus right now, leading up most of this year, will be on the bar exam. So there may be resources that have to be redeployed to different places. So if we decide, and there really isn't an action if we're going to leave the strategic plan as is. If we decide to leave it as is, that's fine. We can continuously review those actions within the operational plan and work with within the state bar, my team, leadership team, to prioritize those.
Any other comments from trustees? Yes, Trustee Gore.
So this might just be a mechanics, so I need some help. So in the survey, funding and fiscal and partnership, I think is trying to get at, the cliff for some of the financial, but I don't know how to map that to the 4 goals, because none of the 4 goals, right, speak to financial stability or longevity. So I feel like either we got to add something, 1A, 1B, or it doesn't feel like it's being addressed.
There is not a specific goal about either financial stability or however you would want to phrase that. I think we could, if to the extent, say we're talking the grants, public-private partnerships, that could go towards protecting the public, engaging partners. It can go towards the general goal of access to justice. I think we can fit it in there if we want to, or we could call out a specific goal.
Yes, Trustee Stevens.
Thank you. This is very helpful, but I do think we would benefit from some additional information in terms of how we're prioritizing, and the in-progress schedule was really helpful. It would be additionally helpful if we saw that it was triaged to priorities. So like there's 11 items under IT, but not all of those, I wouldn't think, would be high priority, right? I think it would be helpful if we could see how the in progress and the unstarted items were prioritized or triaged, so that we could then we can say that lines up with strategic goal number 1, that lines up with 5. And go from there, I think, in terms of giving a green light. Because I know you're going to make very educated decisions about what takes priority, but it would be, I think, helpful visually for us to be able to see it.
Okay, so that's something we would have to work on and bring back, just because I don't have it here with me today, and I'd like to work with the teams closely. I know they all have looked recently. They just did a status update, which is why we have the written report to know what has already been accomplished and what is yet to be accomplished. We can pull up by when they're to start, and then I can work with each area to determine their priority, but we would have to bring that back to the board.
Well, and to Trustee Good's point, it's a lot. This is so much. And I do think that we, the board, are gonna have to make perhaps some helpful calls for you all about what gets done and what doesn't.
Very good. Trustee Grandi.
Oh. And I think along with that, and I know some of these some might be completely new, but just to know which one of these could bring additional revenue to the bar, which ones will maybe have a high cost up front, but it may have long-term savings, because I think that would also help me look at what would make sense for us to, because there might be something that might take initial several hours up front, but the payoff in a year or 2 years will, it'll just be substantive. So I think that those numbers are important.
We can look from that angle as well as we look at priority is cost or return on investment.
Any other thoughts before we move on?
My only.
No, go ahead.
No, my only other sort of question was, under the surveyed initiatives, under that slide, the first point is incentivize pro bono legal services, and the use of the word incentivize maybe confuses me just a little bit, because if it's pro bono and it's not monetary, right? That's not what we're talking about. It is a campaign or an effort to try to get expand pro bono legal services.
Yeah, I think it's more of ways that we can better encourage or outreach to the legal profession to do those pro bono hours.
Maybe like a gold star. Maybe like a gold star or something.
All right. Sorry. Trustee Barahona.
Yes, just to go back to Trustee Gore's comment on the financial kind of piece, there's so much already happening, I think, in that vein, that we should call it out specifically, and sort of build off what's already happening. And I think just state it and articulate it. I think that would be helpful. And I think also it is too much. And so this next pass and version, my hope would contain less items, because I think that staff capacity is real, and what we do, we want to do really well. So yeah, just put that out there.
Do you want to add a specific goal 6 related to financial stability or opportunities, or is it like we can work on that today, or staff can work on some language and bring it back when we're bringing back kind of the assessment of the activities yet to be done?
Yeah, I think staff would know best there.
Okay.
Because there's so much happening, I think, already towards that, to that vein.
Thank you.
Again, anything else before we move on? All right. Thank you very much, everyone. Next is item 6.1.
Mr. Chair?
Yes.
So when would we expect the item, do we think, to come back?
I can do my best to get it back in February.
Next is approval of the specified contracts pursuant to Business and Profession Code, Section 6008.6. And our principal financial analyst, Grisel, will present this on virtual.
Hello. Hi, good afternoon, everyone. My name is Grisel Zendejas, Procurement Principal Analyst. Today, I will be presenting the contracts that require your approval. Before I start, I would like to note that the agenda has been updated. We removed item number 2. It will be brought back at a future meeting. So for now, I will present the remaining 14 items. So I will go down the list, discuss those, and if there are any questions, I'll be happy to address any of those. So I will start with item number 1. That is for Otis. This item's for the Los Angeles building elevator modernization. This project was evaluated by GVK Elevator Consulting. They worked with General Services to develop scope, help with the technical and commercial review. JVK Elevator Consulting provided a summary of the bids, recommendations for overall best value. Based on this evaluation, Otis was selected. This project includes the modernization of the 2 passenger elevators and also a 3rd service elevator in the building. I'll move on to item number 3. That's for LTEC, doing business as SoftFile. The purpose of this project was to scan and index paper files in the San Francisco office so they can be stored and accessed in electronic format. Recently, additional files were identified that needed to be scanned. Therefore, before the contract expires in March, the office is requesting additional funds and extension to the end date through November 2026 to complete the scanning of these new boxes. The office anticipates that the scanning and the review project will be completed by November 2026. Then we have item number 4, that's Joe Auto Parking. This is the parking lot that's located next to the Los Angeles office. This agreement is part of the original building purchase agreement. We pay for the parking spaces at this location. So this request is for that parking funding of 2026. We have item number 5, that's audit file. This request is from the Office of Regulation. This contract covers software subscription, ongoing support for compliance review. The State Bar's Client Trust Account Protection Program, CTAB, requires mandatory compliant reviews of licensees' client trust accounts. That was starting in 2025. After reviewing other vendors' audit file satisfied all the requirements for the program. They were successful last year, so this contract is to continue the new subscription and the support of the program. Item number 6 is Buchalter. This request is for increasing the funds to cover legal services provided to the State Bar in connection with the sale and leaseback of the 180 Howard Street building in San Francisco. This will cover all legal services used related to this lease. We have item number 7, Egan. This is an IT purchase. Egan provides software maintenance and support services for Pro Law case and document management system. The request is to cover the annual renewal of the software for continuous operation. We have item number 8, also an IT purchase, Sendesk. This is for additional purchases of licensees. They provide support for IT incident management operations. So essentially, these are the tickets that State Bar staff submit for requests when they ask for issues or anything that they need to support. IT uses the system to track and monitor those requests. We have item number 9, the National Center of Civic Innovation. This request is from admissions relating to the positive mindset intervention services to the California bar exam applicants. This contract is to cover the 2026 reports, strategies, and the program. And the remaining items, 10 through 15, is also from admissions, but they're all relating to the July 2026 bar test sites. These locations were selected based on location and capacity. The contracts amounts our best estimates based on site rentals, parking, electricals, estimates that the team has received. With that, I will also like to present that at the bottom of our agenda, we have the resolution where we are seeking contingency amounts for item number 1, ODS General Services Elevator Project, and also items 10 through 15, the July testing sites, the table 2 and table 3 show what those contingency amounts would be if they were to ask for those amounts. They all would be to cover any unforeseen costs, and they would only be added if they are requested. We're asking for this contingency because it would help quickly increase the funding without any interruption if we are in between board meetings. So with that, I will conclude the list of contracts. If you have any questions, I'll be happy to address those.
Are there any questions?
The total contract value, right? That's what we're approving?
Correct. Table 1.
All right. Anything else? Trustee Soil.
I do have a couple questions. On item number 1, the LA office, the elevator modernization, we've seen this before, right? And did we not do this in some form or fashion at some point, or did it get delayed or postponed? Or I just remember seeing this line item previously.
I'm not sure if there was like a budget discussion, but at least for now, they're at the point where they have the selected vendor and they're ready to move forward with an executed contract. So from my knowledge, I'm not sure what has been presented in the past, but it might have been a discussion of the project overall.
Yeah,
And it could have been, sorry, Trustee Sala. It could have been for our SF building at the time when we still owned it. This is for the Los Angeles office. I don't believe there was one for Los Angeles, but we can certainly. Araceli, do you have an explanation that would be helpful?
If we have to do it, we have to do it. I'm just trying to remember. I think I've seen it before.
There you go. I think we have discussed it in the budget, but this project has been kicked. So it was supposed to, I think, happen in 24 and it didn't happen. Okay. And then we put it in the budget in 25 and it still didn't happen. Maybe that's the recollection you have, but this is now the first time that it's been for approval in the contracts agenda item. It's supposed to finally happen in this year.
Okay.
Perhaps.
Thank you for that. My second question, and I've had some discussion with Araceli and also with Aline about this, is contract item number 4, and this is the parking. And my question here is, we have a number of staff members that are working from home now. We have parking in the building itself, and so I had a question as to why it was that we actually needed additional parking, and it just may be good for either Araceli or maybe Aline to talk a little bit about this item, because I do think it warrants some additional review.
Okay, you want to go first?
I can share some of the details I learned about this particular contract. So this contract was entered in 2020, around November of 2012, and it was part of the parking spaces was part of purchasing this building. It is a parking easement that we have to pay in perpetuity, or as long as we hold this building or own this building, the LA building. I asked our Director of General Services for a little bit of background, and the executive director at that time made the determination to buy this building, and the owner of this building also owned the parking lot, and the owner insisted that those two be purchased together. And the executive director at that time made the decision that we were going to enter into that parking easement. I believe today we're paying for 47 spaces. As of 2026, only 15 of those are actually being used. But we're on the hook for paying for those 47 spaces in perpetuity as long as we own this building, unfortunately. Elena, I don't know if you...
I was just going to add that there was a request made of Office of General Counsel to consider what options we might have from the legal perspective to reduce the number of the parking sites or find alternative ways if we're not fully using the parking spaces. And so we're reviewing that. We haven't had an opportunity to fully analyze what remedies or what options are available to us, but we'll report back to leadership or the board in appropriate forum on that.
Okay, thank you for that.
But it sounds like at this juncture, we can't remove that from this list because it sounds like we need to make this payment. And this would be on a going forward basis that we would have to, you'd come back to us?
Correct. Well, I don't know if this can wait till February. Erica, did we get a response? Okay. Okay. So whether or not we can wait to bring this back to the board in February, unfortunately, I'm not the right person to ask. Maybe we could get that information. May take a little break, go to a different item, and come back to this. But I just don't have that information.
Yes, Trustee Stevens.
Maybe we can go in the parking sublease business.
There you go.
There you go. We all thinking the same thing.
I'm a problem solver.
Yeah.
I'm a problem solver. But I do want to know if we can put a little color on the contract related to the National Center for Civic Innovation. And I'm not clear on what we're doing. Is that part of accommodations that some test takers have? Because my understanding of positive mindset intervention is it's essentially therapy to help with depression and anxiety. And so maybe Donna, you can give a little, help me out with that.
Absolutely. So we have been contracting with researchers since July of 2018, first with the University of Indiana and Stanford, and then through sort of other organizations that these researchers have moved to, ultimately now to the National Center for Civic Innovation, to do this, what was originally called Positive Mindset, then was called California Bar Exam Strategies and Stories. At one point it was called Mindsets in Legal Education. I think it's gone back to Bar Exam Strategies and Stories, but this is a program, and I was going to talk about this actually a little bit tomorrow. This is a program that is designed to give to help people deal with with like situational friction. People who, if you're coming into the bar exam, doubting your abilities, thinking that you're not right, dealing with the stress of not being of the stress and fear that you aren't going to pass the bar exam, and it's a program that that the results have shown that it's increased bar exam pass rates by 17 points on average, 20 points on average for more underrepresented groups. It's one of the things that we have done in the past to try and improve outcomes for underserved populations. And it is open to everybody, but it has shown that for first-gen populations, for certain underserved groups, it actually improves the passage results on the bar exam more than others. One of the things we had just received a report this past month in December summarizing the last 10 bar exams at which they they administered this and what those results are. And what I was going to suggest tomorrow is that maybe we put that on the agenda for your May meeting, and we can talk about the results. We could potentially bring the researchers here to share that information, to talk about the psychological friction that it is attempting to disrupt, and the results and the positive results that we're finding of that.
Do have an answer in response to Joe's parking. It looks like we actually have an obligation to pay by February 1. We won't have the issues resolved that Aline discussed. So if somehow we are able to do something within that contract and it reduces the amount, of course, that amount will not be spent, but we do need some time to explore that. So most likely you should approve today so that we can meet our obligation on February 1st. I should add that's split into monthly payments. So we'll pay the February payment. If we somehow figure a way to lower it, that may change for the remainder part of the contract.
Okay, Trustee Tony.
I really appreciate this discussion. In the past, these items have often shown up on consent, and I like the opportunity for all of us to spend a little bit of time. So thank you very much for that. On the issue, Trustee Sol, thank you for asking your question about the elevator. I remember it seems like we've approved the elevator several times, but I appreciate, Araceli, your explanation that this time it's a contract, not a budget, and there's a difference, okay? And I get that, okay? And it needs to be done. We know this. I also appreciate the inquiry about the parking spaces. I've never heard of that before in the past 5 years. It's a good piece of education, and I also like people's idea, like, if we own these spaces, we ought to be getting income from them. Come on, folks. That's the easiest way to solve that. We can figure that out. Okay, let's rent them out. Somebody wants to park. My actual substantive question has to do with item number 6, and this is the legal services. Legal services dealing with the sale and leaseback of 180 Howard Street, the San Francisco offices that the State Bar used to own and has now sold, but we're leasing back part of the space for our offices. And I guess my specific questions is I'm interested in learning a little bit more about what the words oversight and monitoring means. You know, maybe what was learned from that. I'm more interested in lessons than in, due to an oversight and monitoring, the State Bar incurred expenses in excess of the board-approved amount, yada, yada, yada. And then I'd like a picture of, like, we should be pretty close to the end of this. I mean, it's sold. We're leasing it. I just want to make sure this isn't going to be an ongoing expense.
Thank you, Vice Chair Tony. Hopefully I can answer your questions for you today.
Thank you.
So the best that we can tell is we've been looking at some of the documentation, because with this contract, for OGC-related contracts, we typically have our own OGC staff monitor each invoice, and we have a detailed tracking spreadsheet for each of those. For this contract, it actually was not monitored within, well, it wasn't tracked within OGC. We had another department. So I think there was a little bit of a breakdown with that. But from best we can tell, it may have been a clerical error. As noted in the item, there was a $100,000 approval and then an additional 83. We think what might have happened is that perhaps it was entered as being $283,000 for approval. So when additional invoices kept on being processed, it may not have been seen or flagged as being over the amount. So this was hopefully just an anomaly, and based on a review of other invoices, we track those very carefully. So in my experience, it is an anomaly. So in terms of your question of shouldn't we be mostly done, and the answer is yes. And so as reported in the outside counsel spend report back in 2024, the total amount spent at that time was $282,000 and some change. Since then, there was an additional $1,200 incurred, and we've just added a little bit of additional padding in case some specialized questions come up since that time. So that's why the request is to get up to 300.
Okay. So it's not an additional 300?
No, it's so we're seeking retroactive approval for the amount already incurred.
Got it.
And then an additional padding in case there's additional services that are required as we're working through some of the lease issues that have come up.
Total contract is capped at 300?
Correct. It will be capped at 300, correct. And so I think the total spend so far is $286,000, give or take.
Great. Thank you very much for that. I do have one other question in general. It has to do with the sites for the July 26 exam sites. I'm interested in how the proposal came up with 30% as the request for the unforeseen costs. I ask because 30% sounds like a lot to me. It sounds like, if in my budget I had 30% unforeseen costs, my board would be asking me questions. And so I certainly understand the 12% that's in the first item on the elevator. Okay, that's fine. 30 seemed a little high. I'm trying to figure out how you got to it.
Happy to take that. The first time that we introduced this concept, I'm not sure if it was the last meeting or the meeting before, we introduced this meeting before that, Erica's pointing and telling me, we introduced this concept of ensuring that what we were asking the board to approve was the amount that we have been, that we are negotiating with the, in this case, with the hotel, with the convention center, and that we would then ask the board to provide flexibility for this contingency. In the past, we built that contingency into what was presented to the board, right? And we've changed that process so the board knows the amount. We build in this contingency. We have this contingency. We ask you for the authority to get approval for up to that additional amount. Our research at the time was that 30% was about the number that we usually ended up needing for the bar exam sites. And the reason is this, or one of the reasons is this. When we are contracting for a site, we have an estimate of the number of applicants that may be sitting for the exam. So if, for example, we are contracting with a hotel for a testing accommodation site, and it turns out that we need 40 additional private rooms, more than we originally anticipated, I need a whole other wing or two of the hotel. And they are willing to give that to us, but we have to pay for it. Those are the types of the type of information that comes to us very quickly, and in a very short time before the bar exam. And so in the last time that the board approved an amount for test sites, it did approve that additional 30% authority for the ED and the chair to go up to that level. And so we are asking for the same thing again because of those types of contingencies. The electrical is going to go up if there are more people who are seated, but that really is the driving factor, is more people is the number of people who we need to seat at each of the particular sites.
Thank you.
Any other questions?
I'm prepared to move the item.
Fantastic. And a second?
Second.
Yeah, okay. Motion by trustee Sowell, second by trustee Stevens. Vote, please.
Barahona?
Aye.
Buenaventura?
Aye.
Good?
Aye.
Gore?
Aye.
Grande?
Aye.
Harrison?
Aye.
User?
Aye.
Giorgiello?
Aye.
Sowell?
Aye.
Stevens?
Aye.
Tony?
Aye.
Cisneros?
Aye.
With 12 ayes and 0 nays, the motion carries.
Great. Next, the board will move into closed session pursuant to Government Code Section 11126, Subdivision E2A, and Business and Professions Code Section 6026.7, Subdivision C6, and Section 606.1, Subdivision C. We will, of course, be switching to our other Zoom, and we estimate we might be back from this closed session and able to report out anything that is reportable in 30 to 45 minutes, maybe an hour.
Probably more like 20 to 30.
Probably 20 to 30 minutes. So stay tuned, and with everyone's help, we'll go into closed session. Thanks, everyone. No problem.
We are now live and recording.
Great. Welcome back, folks. We are coming out of our closed session of the California State Bar. There are no reportable items to report out of this closed session. With that, we have completed our agenda of business for this meeting. We will be reconvening this meeting tomorrow morning as a joint meeting with the California Bar Examiners. And Laura, if you want to give a description of how that's going to work.
Certainly. So tomorrow morning, as Chair Cisneros said, we will be meeting jointly with the Committee on Bar Examiners here in Los Angeles. We'll also have the Zoom link available as well. We will be having both CBE members and board members. Will extend the table space, but we'll all be up here going through the meeting materials. We expect the meeting to go into early afternoon, estimated 2 p.m., and that is because the CBE will be continuing with their own business meeting after we are completed. All of the materials are posted online, and you can take a look at the agenda as well. Thank you.
And with that, we will end the portion of this meeting agenda for today and reconvene this meeting at 9 a.m. tomorrow morning. Thank you, everyone.